Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I'll be your guide through the next 4 hours of Courtlandia. It's good to be back after a couple of days off. Let's start in Lenawee County, Michigan. This is Judge Anzalone.
Name, please.
Stephen Wood.
All right, let me grab your paperwork. Sir, we'll get to you in just 1 minute, okay?
Thank you.
All right, this is in the matter of Amanda Wood versus Stephen Wood, file number 2020-47464-DM. So, Mr. Wood, we are here on a failure to pay child support. There's a monthly charge of $3,145. Your arrearage as of today is $97,303.59. This is your 14th show cause. The last payment we received was $1,500 back on November 15 of 2024. There was a child support review that was scheduled at probably your request. You did not appear or provide information. The show cause has been outstanding for over a year to provide you opportunities. Mr. Wood, obviously you're facing up to 90 days on jail on this. I don't know if there's been a felony charge yet, but you do have a right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you, Mr. Wood?
No, Your Honor.
All right, so Mr. Wood, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so let me here. So, Mr. Wood, do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes, Your Honor.
Okay. Hold on. I'm asking questions yet. Hold on. Was he picked up and charged with anything else? All right. So, did you see him for anything else?
I'm looking. Child abuse on the bottom of under new arrest.
Just me? Okay. All right. So, and you understand, Mr. Wood, you're well above the limit where you could be charged with a felony. Do you understand that?
Yes, Your Honor.
All right. And there's also a failure to appear for court on February 25 of 2026. Do you understand it's also a crime to fail to appear in court when ordered to do so?
Yes, Your Honor.
All right. Do you understand that if you plead guilty to either of these offenses, I could sentence you to jail up to 90 days? Do you understand that?
Yes, Your Honor.
You're entitled to a trial and you cannot be convicted unless the evidence at your trial proves that you are guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You're entitled to have an attorney represent you here today and in all subsequent hearings. Do you understand that?
Yes, Your Honor.
If you want an attorney and you cannot afford to hire one, we will appoint you one at public expense. Do you understand that?
Yes, Your Honor.
Do you want an attorney appointed to represent you?
No, Your Honor.
All right. So, Mr. Wood, you are entitled to have all the witnesses against you appear at your trial, and you would have a right to question those witnesses while they are under oath at your trial. Do you understand all that?
Yes, Your Honor.
You're also entitled to have me order any witnesses you might have to appear at your trial on your behalf. Do you understand that?
Yes, Your Honor.
You do not have to say anything at your trial, and if you do not testify or say anything, nothing will be held against you, and in fact, no one will even mention your silence. Do you understand that?
Yes, Your Honor.
On the other hand, do you understand that you are entitled to testify at your trial if you want to testify?
Yes, Your Honor.
All right, how do you plead to the charge that you failed to pay child support to the very best of your ability up to the amount ordered? Guilty or not guilty?
Not guilty, Your Honor.
All right, and how do you plead to the charge that you failed to appear in this court as ordered on November 15 of 2000, or wait, let me see, it was failure to appear February 25 of 2026. Guilty or not guilty?
Not guilty.
All right, so I will set this for trial. Is this your file, Ms. Herron, or?
What's that, Your Honor?
All right, Mr. Wood, do you have any witnesses you'll need for trial?
No, Your Honor.
All right, Ms. Adams, can I set this for sometime tomorrow for 30 minutes? Miss
Jane?
Science. Tomorrow, maybe?
How much time did you say?
About half hour, and I'll need a prosecutor.
Okay, we could probably do 11:30 or 1:30 is now open.
Let's do 1:30. All right, so Mr. Wood, I'm gonna set this for trial tomorrow at 1:30 p.m. We'll have a prosecutor, Ms. Herron, available, and I will set your bond in the amount of 10,000 cash. All right?
Your Honor, may I just tell you about this one thing? I have been paying child support, but it's through the VA. It goes directly to Miss Wood.
Ms. Herron, is that something we're aware of?
It's in the amount of
Yes, Your Honor.
$526.
Hold on, Mr. Wood. Ms. Herron.
That's why there was a child support review petition for.
Right. So, Mr. Wood, there was that hearing was scheduled and you didn't show up. So I'll set this for hearing tomorrow at 1:30 p.m. We'll see you back then. All right. Thank you. And Ms. Herron, you'll need to reach out to Ms. Wood as well. All right.
Yep.
All right. Thank you. All right, you want to come back up? So Mr. Pierce, yep, come on up. My bailiff's gonna come over and grab the receipts. This is back on the record in the matter of Melissa Francoeur versus Terrence Pierce, file number 2019-46386. Yes. All right, my bailiff is now handed to me. Receipts from expert pay and $250, $256.25 and 200 and let me see. Two transactions of $256.25, Ms. Herron. So, all right. So, Mr. Pierce, your arrearage is really high. So, you're making payments. So, I'm happy with that. You need to petition for a referee hearing, and you could probably get, you know, and then an income review. Okay, and they can do that all at once. And I think, does he get that paperwork up here or downstairs, Ms. Herron?
You can come down here and grab it.
Yeah, go down to front of the court in the basement, get the paperwork to file that. I'm gonna adjourn this out to June 8th at 8:15 in the morning and follow through on it, like show up for the hearing and do what you need to do, okay? At that hearing, if you don't agree with the result of it, you can always object to have it heard by me. Just make sure you show up and do the paperwork within a time, all right? All right, good luck to you. June 8th at 8:15. Go downstairs in front of the court. All right, let's see.
Okay,
Hey, this is Judge Anzalone. I'm ready for David's signs too.
All right, we'll get them in for you.
Thank you. Bye. Becky, did you bring me paperwork on signs?
I never got anything on signs.
Joanne, we don't have paperwork on signs.
They have it on the rush sheet for you.
Well, they do, but until we get paperwork, we can't see them.
You want me to just wait till you call me or?
Oh,
I'll be over there.
yeah. Okay.
Looking.
Hey, this is Judge Anzalone.
Well, Judge Anzalone lines up the next contestant. Good morning once again, everybody. TCF Live. It's Monday after Easter. Good to have you all here. I hope you all had a good holiday weekend. Mine was weird. It was website migration, taxes, and a power outage. That was pretty much our weekend. But good to have you all here and good to be back. So real quick, Barbara dropped a link for Substack in the chat. We now have Substack. It's going to kind of be a center point for the various media that we do. So be sure to join me over there. I'm going to do some writing. Also, we are simulcasting over there on Substack right now. All shows will now be pushed over there as well. So please do sign up if you're not already.
So we are here today on a parenting time complaint that was filed by Miss Meyer against Mr. Meyer. Parties had a referee hearing and an order signed February 23rd of 26, giving Christiana Meyer makeup parenting time. She states that even after the hearing and order that he is still refusing her parenting time. So both of you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Miss Meyer?
Yes, Your Honor.
Mr. Meyer?
I do.
All right, so I don't have your full civil file just because it's a show cause. So you're both under oath. There's some tissue there. Spit out your gum. So Mr. Meyer, what is the current custody arrangement between you and Miss Meyer?
She has week on, week off with the two younger kids, and I have physical custody of my oldest daughter.
Okay, and so do you understand she's alleging that you're failing to give her week on, week off parenting time?
Correct.
Do you understand that's a contempt of court? So if the court were to find you guilty of contempt of court, I could sentence you to jail for up to 93 days.
I understand.
Okay, now, Ms. Meyer, when was the referee hearing?
Our latest one was February 17th or 14th, I believe.
Okay, and at that time, they ordered makeup parenting time.
Right.
Okay, and how did they order that to be done?
That I needed to notify him of what days, and he's refused to. Since then, until I got 2 out of 3 kids yesterday, he's still.
So the oldest child that he has full physical custody of, so you're getting the younger ones
Yes.
for your week on, week off?
As of yesterday, I went 3 months. I didn't see him for 3 months. I didn't see him from the week before Christmas, and so you ordered to give him back to me on Monday.
Okay, and the oldest child, he has full physical custody of?
Yes, and I'm supposed to have every other weekend with her.
Okay, and how old is that child?
Just turned 16.
Okay. Okay. All right. So how is parenting time with the 2 youngest going?
Not well.
Not well. Okay. Is this something where counseling would be a good idea for you and the kids?
Yes, and allegedly they're already enrolled, but I asked them, because they're supposed to be doing weekly. I asked them yesterday via text if they had any appointments or after school activities that I should be aware of, and he's ignoring me and not responding.
All right, but you have joint legal custody.
Yes, so I have to figure out where they're going and what time the appointment is, I guess, on my own, or he could just tell me.
Okay. But that's their individual counselors, right?
Well, this is what he's told me via text, so he's left me completely out of the loop in the last 3 months, so this,
Okay.
I assume, is personal counseling.
All right, so typically, if you have a personal counselor, that's different than family counseling, okay? Because the personal counselor is their counselor, you know, there's a rapport there and trust. To expand it to family counseling, perhaps between you and the children, it would be using somebody else. So that way it's an independent party and, you know, their personal counselor doesn't have a conflict. Okay. Mr. Meyer, do you think counseling for her and the children would be appropriate?
Very much so.
Okay. Now, where are they going for their personal counseling?
Adrian, counseling and psychiatric care.
Okay. All right. And how often do they go?
Lydia's been going since she lived with me first 2 years ago. Delilah and Eli both started when they came. She asked them to leave when they first came with me. When they came, I figured it was time to start counseling. They need somebody to talk to and a voice. So they've been in it. Eli's, I have proof right here if you'd like to see.
No, it's okay.
I have like dates of when they started. Eli's been in it for a couple months.
How often does he go?
Weekly.
Weekly. And what about the other children?
Delilah goes weekly, but there was a hiccup with her insurance, so she went like twice and then had to find another counselor that accepted her insurance. So it was broken up for a couple weeks, but she's been enrolled maybe a month less than Eli. She took a little bit of convincing, but that's where it sits. They've already been enrolled before court order.
Okay. All right. So, all right. So, Ms. Meyer, a couple things, like their counselor is not going to tell you what they say. Probably not telling him what they say because, you know, they do work very hard to establish trust. And so, you know, you can call the counselor and just say, I am available. If you ever want to bring me into a session with them, please know I'm available. This is my contact information. But perhaps, Mr. Meyer, do you have health insurance?
I do not.
And you have health insurance?
Yes, ma'am.
Okay. So, family counseling is probably necessary here. And I would leave that, what I would say at this point is I'm going to leave that to you to find a counselor. One, do you got insurance through the state?
I don't qualify.
No? Okay.
And I can't send my work insurance.
And you'll have to pay out of pocket for any expense for you.
Happily.
Yeah. And then are they through your employer or through My Child?
The kids' insurance through My Child.
Okay. And so just know that their insurance is through the state of Michigan. So I would start looking for places locally that would do family counseling. Counseling is great. I recommend therapy for everybody. So, okay. So I think that's the first step in this situation to get back to a healthy relationship. So what I'm going to do is I'm going to set this out to like June 8th. Okay. You are seeing the younger ones, the older ones, that's going to be a tougher nut to crack because older kids typically are, but I am going to order therapeutic counseling between mom and the 3 children. Sometimes the younger will be more willing to go and you can do it on your time. Make sure it's on your time. So you're taking them. And then eventually, hopefully the older one will go too. Okay. And so I'm going to order that and I'm going to leave that to you. She's going to locate somebody. And how do you guys communicate?
We're ordered to communicate through the
App close?
Yes, ma'am.
App close? Okay.
Or I'm not sure it's called that. I have it in the paperwork. It's like the intermediary website that you order.
Yeah. Do you know what it is?
No, I need to familiarize myself with that.
Okay. So I think there was a prior order probably for app close.
Okay.
And it's just an app that you download. I think the first year you can get a waiver for the cost of it. If that's cost prohibitive, what I've had people, what I've recommended is maybe starting a new email address just for communications between the 2 of you. And that way there's a separate email just for your communications if you can't afford the app close. It used to be free, now it's not. So I'm going to order that the parties use app close to communicate, that plaintiff is to make arrangements for therapeutic parenting time. And sessions of just being once a week you'll go, or however often, every other week, whatever it might be, just to work on any issues. And then we'll come back on June 8th and see if we have any progress. Okay, because it might take a month to get into counseling. Okay.
How do I go about establishing my visitations with my elders?
So,
Not ask my children to leave either, by the way, that was a lie.
okay, so he's 16, she's 16. So the problem we run into here is if he tries to physically make her go, he can be charged with domestic. If you try to physically make her go, you could be charged with domestic. So I think that we encourage her to be part of the therapy and start there. Because I don't know, obviously the referee did a full scale hearing on this, but I'm going to order the therapeutic counseling for all 3 children. And we're all going to encourage her to go with the younger children. All right. And hopefully she goes and hopefully we start to build this relationship again.
Yeah, he's doing everything he can to stand.
Well, he has a version of events too. So unfortunately, so you're to find a therapeutic counselor. And like I said, you guys can sign up at AppClose or do an email address, whatever you choose. Just communicate that to each other. Do you guys communicate at all? Text?
Yeah, when he wants to cut me down, he does.
Okay, so you can send the AppClose information to him and vice versa. All right. And then we'll come back on June 8th and see where we're at. Okay, thank you.
Your Honor, it's not still contempt of court.
It is. But you have the.
Okay, friends, let's move on. Huron County, Judge Prill. But before we go there, Ashley is celebrating 1 year as a channel member. So thank you, Ashley. And in honor of you, this Huron County case is actually People versus Ashley. No relation, though, I imagine.
Kowski. The defendant is here based upon a plea previously entered before this court on February 2nd, 2026 to child abuse in the 3rd degree. Ms. Karen Everland's prepared the pre-sentence report and stated March 20th, 2026. Mr. Rooney, have you and your client had the opportunity to review the pre-sentence report?
We have.
Are there any additions, deletions, corrections, or objections in the report?
No to all those questions, although I did submit a character letter.
Yes, and the court reviewed it. This is a letter that's dated April 4, 2026, prepared by Patricia Barron, B-A-R-I-N. Court has received that. Mr. Kowski, have you received a copy of it?
I have. We have no objection to the court considering that.
All right, thank you. Ms. Robinson, any objection to the pre-sentence report? Mr. Kowski, any objection to the report as well as guidelines?
No, Your Honor.
Thank you. Any objections to the guidelines?
No, Your Honor.
All right, thank you. Mr. Rooney, what would you like to say on behalf of your client before the court imposes a sentence?
Well, Your Honor, my client is just 21 years old, I believe. No prior criminal history of any kind or juvenile history. They take full responsibility for not supervising their children properly, not monitoring the water temperature in the bathtub where they got their feet burned. Since this incident has happened, she has been involved with CPS. She's completed 4 different certificates so far through the DHS. Some of the names of these courses are Back to Basics, Thriving Together, ACEs, which I think is Parents Advanced Childhood Experience, another class called ABC, Early Literacy. So she's been busy getting educated on how to be a better parent, basically. She does have supervised visits with her children scheduled with CPS. She's going to be engaged in counseling through Great Lakes. Guidelines are 0 to 9 months. Recommendation, unfortunately, was made to be 9 months. I have to say, though, in all my years being a criminal defense attorney, I cannot recall. Maybe it's happened, but I don't believe I've ever had a client get a recommendation at the top of the guidelines. Not that it can't happen, but I honestly cannot recall that ever happening in my experience. you know, I rarely disagree very strongly at all with the typical recommendations. In this case, I do strongly object. Not to the extent of pounding my shoe on the table or outside the bounds of decorum, but I'll tell you why. I absolutely agree that she was negligent and totally responsible for her twins that are, I think, 2 years old now, getting their feet scalded. And she pled guilty to that and did take responsibility for it, and I agree that that shouldn't have happened. Kids need parents to protect them. And I could agree that maybe a taste of jail might have the intended effect of impressing on her the serious responsibility of being a mother. I'm not her attorney in her neglect case, but I've warned her that should her children ever be in a similar situation in the future, I have no doubt that CPS would be trying to remove her kids from it. So she is aware of that and takes that very seriously. The reason why I think the recommendation is way too much is I think she has to continue to do the programs through CPS and get involved with their counseling, and probably most importantly, to not break the bond with their children for 9 months because there's no visits in jail. So that's why I think 9 months is just way out of bounds in my opinion. Now, if she fails to follow through with CPS, fails to follow through with her visits, fails to do her classes, fails to do her counseling, I think all those ones should be on the table. So I'm asking essentially for no jail, pending her following through with all of her CPS requirements.
Ms. Robinson, is there anything you'd like to say?
Yes, I've actually brought me something. Your Honor, I've spent the last 5 months doing visitation. Like my lawyer said, I've completed 4 parenting classes. I spent every day the last 5 months reliving the incident that got the kids taken. Regretting walking out of that bathroom even for a second, knowing I have no one else to blame but myself. I now realize even though they can walk, talk, and feed themselves, that does not mean they can be left alone. I have since learned from my mistakes and now I'm asking for
Mr. Rakowski, anything on behalf of the people?
Your Honor, we believe the pre-sentence investigation is accurate, and we leave it to the court's discretion to fashion a fair and just sentence.
Ms. Robinson, you're 21 years of age and have no prior record involved. None. High school graduate, a parent. And when the court took the plea in this case, I couldn't help but think about those 2 children. I didn't know the word debridement before, debridement. And I think that's how you pronounce it. But these 1-year-old twins sustained severe burns to their feet. And debridement means removal of tissue. I'm assuming to remove the damaged tissue based upon what these children went through. And, you know, maybe I'm old school, but I remember the days when it came to bathing our children, and actually that was my job as a parent. And it was awesome, frankly. You're spending time with your children, but you're watching everything they do, because whether you place them in a bathtub or if they're really young in one of those portable type of things that fold out, hold water, but you have to be on constant watch of these children. I mean, you can't walk out of the room. And not only did you walk out of the room, but you walked out of the room for a few minutes. These children had, what happened if they slipped? Or you find them face down in the tub. I mean, as a parent, I'm thinking to myself, oh my goodness, how in the world could you do that? And then not only leaving them alone, but in such hot water that they had to have tissue removed from their feet. Now, I understand it was only a couple inches, but it didn't make any sense when you read the pre-sentence report and it doesn't appear that there was burning to their bottom, so to speak. It was essentially their feet. And the court does take judicial notice of the NA file. We can't speak about it, what's going on with it, but the whole idea is when you are a parent, you have certain responsibilities. You have certain duties you have to follow. And the number one duty and responsibility is to your child, in this case, your children. All I know is when we brought our first child home, and my parents were there, my wife's parents were there, all the aunts and uncles were there, and then all of a sudden, they're all gone. And it's just two people and the child. And then it just came upon us, oh my gosh, this is our responsibility now. And we had to be responsible. Were we perfect? No. Were you perfect in this case? No. But a message has to be sent that you understand that your children are the most important commodity in your life, above a significant other, above a parent, above a friend. Your children are everything. You die for your children, essentially. And you can look upon this case in a matter of ways. One, you could say, lock her up, throw away the key, you're a terrible parent. That's one way of looking at it. On the other side, you have a 21-year-old with no prior record who some people might say, the court's not saying this, but some people might say, you don't have business being a parent. But you are a parent, and you have to be responsible. And there's another side of it that, look, I'm not experienced. I don't know necessarily how to do this. They don't come with a manual. I did my best and I really screwed up. And there's no doubt about that. This is a tough case for the court because the court has to balance the interest of society, the interest of justice, tailoring a sentence that fits with the facts of the case, that comport with the guideline range in this case as well. And the guideline range on this conviction on a 2-year felony is 0 to 9 months. That's it. And some people are going to say, throw away the book. Others are going to say, wait a second, the parent made a mistake, parent needs to step up, parent needs to move forward. Because in one alternative, if I just simply throw away the key and follow the guideline range of 9 months, Mr. Rooney's right. There won't be visitation with those children in the jail. That's an absolute unfit place for the child or children to be visiting their parent. But on the flip side, if the court just says, you know what? No harm, no foul, conviction enters, no jail time or minimal jail time, and then let the NA case address the matter moving forward. And frankly, I don't know what the status is of the NA case at this point. I'm not sure, and I don't want you to comment on it. But I know that I will be presiding over that case as well. And the number one concern of this court, and it has been for years and will continue to be, is these children. That's number one. Even on divorce cases, for instance, when parents are arguing and the court has to make a decision regarding custody, it's not based upon, well, we want to do what's best for the parents, it's best for the child's best interest. And that applies here as well. So with that long diatribe, it will be the sentence of this court. You'd be placed on a term of probation, not for 3 years, but for 5 years. Conditions of probation include the following standard conditions: not to violate any criminal law of any of the government, not to leave the state of Michigan without prior approval of court, notifying the probation agent at least monthly or such times and places the agent may require. You are to complete any mental health or other recommended treatment following an assessment by a qualified community-based service provider, complete the Thinking Matters program, not to engage in any assaultive, abusive, threatening, or intimidating behavior. Clearly, this was not assaultive, but this was abusive. In hindsight, I'm giving you some credit there, but walking away from the children, that's another story. But we'll address it. No verbal, written, electronic, or physical contact with anyone housed within an MDOC facility, nor the same type of interaction with anyone that's engaged in the behavior that constitutes a violation of any criminal law of any unit of government. You may not use any object as a weapon you cannot own, have under your control, area control a weapon of any type. You must not even possess an imitation weapon. You can't be around anyone that possesses those items. You are to contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You are to complete and comply with all written and verbal orders of the agent, submit to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause you of items that violate the terms and conditions of your probation. Any arrest or police contact, loss of employment, or change of address must be reported to the agent within 24 hours. You are to notify the agent of any service of a personal protection order on you within 24 hours of service. You are to make genuine effort to find and maintain legitimate employment at a minimum of 30 hours per week unless engaged in alternative programs approved by the agent. Crime victims assessment of $130, probation supervision fee of $30 per month regular, $60 electronic. Court cost of $200, payable at the rate of $10, we'll make that $5 a month. Fine of $200, payable at the rate of $5 a month. Court's waiving attorney fees. $68 in state costs will be ordered. The probation office is authorized and empowered under statute to effect your apprehension, detention, and confinement of up to 72 hours on reasonable cause you of items that violate the terms of your probation, or they believe you violated the condition of your probation. If referred, you are successfully complete any PA 511 programming based upon eligibility. Over the next 5 years, you shall perform 40 hours of community service. That community service must be documented, submitted to the probation agent over the course of your probationary term in written form. Finally, guideline range is 0 to 9 months. That means it's not a prison sentence. And the court, though it's been placed upon the court that they are to consider the guidelines. As I've stated before, we've had cases out there in other counties where the guideline range was followed, but it was overturned, despite the fact that it was within guideline range. Guideline range is 270 days in jail. That will be the sentence with credit for 1 day served. However, as it pertains to the 270 days, for the first 90 days of the sentence, you shall serve weekends. You will report to the jail Friday at 6 p.m., be released Monday morning at 6 a.m. The remaining jail time will be held in advance. Now, you are sentenced to 270. You are to serve the first 90 on the weekends. The reason the court is doing this is because there is a companion NA case, and most services are provided during the week. By doing so, that will give you the opportunity to continue with services to become a better parent, But there's also that negative side of the sting, that is the county jail time. Understand though, if you violate any of the terms and conditions of the probation, you come back before this court and you're found in violation, don't worry about any programs. They'll be just locked up. That's how important this is. I'm considering Mr. Rooney's argument here, and he makes a valid one. It's my duty to inform you of the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, the court will assign counsel for your public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed at the clerk of the court within 42 days.
Paperwork says, yeah, it was completed.
Okay. I didn't,
Is there a fee or
is there a DNA testing fee?
was it previous $50? So there is.
Okay, the court will order that. I didn't see that in the recommendation, but we've got it covered.
I'll pay you out another 3.
Oh, yes. Thank you. You are to also waive confidentiality and allow treatment programs you're required to attend to disclose information to the agent. Good luck to you, Ms. Robinson.
Thank you.
That'll be all.
Good morning once again, friends. TCF Live. It's Monday. Greetings to Lindsay all the way over in Paris today. I hope you guys are having a good time and look forward to having you back here with us next week for Sidebar. Sidebar's off this week still, but we'll be back next Tuesday, and I know Ellie is excited about that. I gotta say, with regards to this case, I think it was a little harsh, personally. You can tell me what you think in the chat, but you know, parenting does not come with an owner's manual, with an instruction guide. I'm going to go out on a limb and say that she probably was not given any skills, either through education or through how she was raised herself, and she screwed up. And the kid got injured, and that sucks. But this seems like a lot to me. I don't know. I always told my kids that the goal of any good parent is to not mess them up too badly, because we're all going to mess up in one way or another. It's just kind of the way it is. But I don't know. If you have different thoughts, let me know in the comments. Let's go Oakland County, Michigan. Judge McGinnis. Let's see what's going on there.
State your name.
Joshua Vance.
Are you still using a mailing address on Sonia Avenue in Madison Heights?
Yes, ma'am.
And are you consenting to this attorney appearing on behalf of the attorney of record today?
Yes, ma'am.
And could you just place your P number on the record too?
Yes, Your Honor, P72322.
All right, thank you. Today is the date and time that we had scheduled for delayed sentencing. Mr. Vance was before the court back on October 6th of 2025. At that time, the court accepted his guilty plea to disturbing the peace, and he was granted a delayed sentence pursuant to 771.1 for a period of 6 months. I did receive a report from Ms. Crandall, the probation officer that was supervising the conditions of his delayed sentence. At the time the report was issued, it indicated that he still had an outstanding obligation to complete a 1-day impulse control class. As I'm out here on the bench, I see that there's been an email sent over that has information regarding that class. What would you like to place on the record?
Your Honor, he did complete that class. I believe the certificate was sent over to the probation officer. So he has complied with all of the requirements of the delayed sentence.
All right, and sir, tell me a little bit about the delay. What took you until the very end of the delayed sentence period to complete the class?
Well, I scheduled it at probably like the middle of March, and I actually did get very lucky that they were able to squeeze me in when they were able to. I was just sitting there and do it all kind of at one time.
Okay, you did complete the other requirements, which included no contact with the complaining witness, no negative contact with the law or new criminal activity. You provided a documentation that you had maintained full-time employment during the time that you were under this type of supervision, and you paid your fines and costs in full on the date of your plea. The people had originally indicated that if you were successful with the conditions of your delayed sentence, that they would allow you an opportunity to have your guilty plea set aside, and they were going to dismiss the case. Is that how you want to proceed today?
Yes, sir.
Is there anything else you want to say on your client's behalf before we proceed?
No, Your Honor, we would request that the court follow the recommendation.
All right, sir, is it your desire today to withdraw your guilty plea? All right, I will allow you to do that with no objection from the prosecutor, and then I'm going to grant their motion to dismiss your case. You'll get your paperwork indicating the case has been dismissed at the front counter before you leave today. Thank you.
Alrighty, just a quick hearing there. Let's go back to Judge Prill. He has a new contestant in Huron County.
There are following files: 257345. Defendant pled to domestic violence third offense. That would have been January 22nd. 7386, 257386H. Defendant pled no contest to a hate crime. 87 FH, that's absconded. 7419, absconding and tampering with an electronic monitoring device, and in 7420, resisting and obstructing a police officer. Now, as I stated, the 45 plea was entered on January 12th, in 7386, February 2nd, as well as 87. 7419 and 20, those pleas were entered on March 9, 2026. Ms. Karen Everland has prepared a pre-sentence report covering all files, and that's dated March 19, 2026. Ms. Weisenbach, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Any objection to one report covering all files?
No.
Any additions, deletions, corrections, or objections other than guidelines relative to the pre-sentence report?
Yes, Your Honor.
Go ahead, please.
On page 9, there is a victim impact statement listed for an individual who is not part of this case. I have gone through all of my client's cases, pulled out all the names of witnesses charged, dismissed, uncharged. I can't find this individual's name even listed anywhere, even as a witness. So I would ask the prosecution to enlighten me if that is incorrect and this person is a genuine victim of this case somehow. But I don't have that he is. Like I said, I went through all of them to figure out like who's witnesses and who's who, and this person is. And then reading the actual impact statement is bizarre because it doesn't fit anything that's been going on in Mr. Cook's cases. So I don't think this individual's PS or victim impact statement belongs here.
Mr. Rakowski.
You can start with Ms. Everline first.
I apologize. Which name are you referencing?
Randall Sturm. Randall Sturm. We know the name, Your Honor, from People versus Matt Shears. Didn't affiliate him with this file, though.
remove that one. I don't. Unless the prosecutor's office has something.
I don't actually. We have no objection to that, Your Honor.
All right, we will strike, beginning on page 9 of the report, where it begins in bold, Office of the Huron County Prosecuting Attorney Restitution Claim Sheet, that entire portion of that page. To the top of page 10 after the name Van Houten. Does that address that, Ms. Weisenbach?
Yes, thank you.
Anything else relative to the report, please?
Not with regards to the report, no.
All right, Mr. Cook, do you agree with that, sir?
Yes, I do.
Mr. Rakowski, any objection to the report as well as comment?
No, Your Honor.
Any objections to the guidelines? Anything you'd like to say on behalf of your client before the court imposes the sentence?
Thank you, Your Honor. Mr. Cook comes before this court. He is a young 30 years old, and he has already been to prison in Michigan and Wyoming. He was sentenced from this court a couple of years ago. So when we were discussing this, he knows what to expect. He plans on taking courses and enrolling himself in programs that can help him. He has, through his wife and himself, asked me how we can consider some alternative treatments for his anger management issues, and I know of none. If this court has them, then we would ask the court to consider that. I've also asked the court to, in review of the PSI, to see that he had a rough start to life. When he was 14 years old, he found his first juvenile offense in 2009. And also in this report, you'll find that he had an extremely abusive stepfather. That's how he lands that first charge when he's the little youngster of 14 years old. He has been mad about things that have occurred in his life that he cannot control. His mother had referred him to the Wyoming Behavioral Institute when he was 16. And in the PSI notes, he just gets mad at little things and breaking things. And his anger comes from, he was separated from his mother. They moved around constantly he moved around constantly between his mother and his father. His father was abusive towards his mother. His stepfather was abusive towards him severely. Just again, as a reminder, that first juvenile case that he picked up was the result of being abused by his stepfather. Then unfortunately, the woman that he was close to, his mother, passed away when he was 19, 20 years old of cancer in 2015. And that has had its impact. That's when you cannot understand what's bubbling inside of you and the feelings, and they leak out. That's where his anger has come from. He had graduated in 2014 from high school, and then he found himself in prison. No jails, no pass go, straight to prison when he was 19 years old in Wyoming. He was eventually out. There was an incident, I believe it was in 2020 here. He was sentenced to prison. Again, no pass go, just go straight through and go to prison, no jail time. So he sat in Michigan prison for 2 years and then went back to Wyoming. Eventually made his way back to Michigan, and there was a time where he had finally completed everything and was released from probation. Him and his wife have been married 1 year at the end of this week, and there was a relatively small incident with her that brought him back to court. And then it kind of snowballed from there. All of the things that are charged, uncharged, dismissed, etc., are to do with being mad and angry and having internal feelings he doesn't have a lot of control over. Continental Reynolds just mad about the gaming system, Northgate Tire, mad about what's going on with this, Walmart, somebody looked at him funny. Everything makes him very, very angry. He's angry at nothing, he's angry at everything, he's angry at everything. And those are the things that we have reports for. I need you to also know there's another side to Shane that there are no reports for, but there's going to be someone who's expected to address this court. His wife wrote a letter that this court should have received, and she does want to speak in court. She is allowed as a victim. So it was a thing about a bird, and he just got mad. So there was that. But you will recall, we were here days before Christmas, and from the screen, he didn't want to talk to me about police reports, this, that, he wanted to talk to you about being able to spend time with the 7-year-old stepdaughter for Christmas. And he probably begged you 3 to 4 different times, and he may have interrupted court, but that was his focus, was to spend family time at Christmas. This is the side of Shane that's not going to make a report. and is barely gonna make it in front of you, but he was begging for that time. So unfortunately, he did sit in jail over Christmas. They did eventually celebrate Christmas with that small child later. So I haven't met Kira Rose, but she does think a lot of Shane Cook, and she is just a small child. With me, he has been polite, respectful, 99% responsive. A couple of times when he's not responding to me is when he's not here in court and he's not going to answer my question. But for the most part, he is in the office when I ask him to be there. He is reviewing paperwork I ask him to review. I had no concerns as a female attorney having him alone in my office. He is very appropriate. We've had good conversations. He gets a little excited about things and we're able to talk him through and work him down. He has been wrongly treated a lot in life. And again, when you don't know where to put emotions, they leak out into places they shouldn't, and that's understood. But he has taken none of this out on me. He has had to be in court or has had these abscondings or didn't get out for Christmas and things to that effect. Again, he asked me through his wife and himself for treatment as a result of where we are now. I do know, he knows just as well as I do, that there are courses in the prison system for domestic violence awareness, how it affects children, anger management, counseling that he needs. And so again, another piece that you're not going to hear from anybody else except from me and from June is that on April 10th, which is the end of this week, they're going to celebrate 1-year wedding anniversary, and they have had continued conversations about their life once this is over. So there is a spark at the end of this path for him that he's looking to pursue with his wife and her child. So I wanted you to be aware, there's two sides to Shane Cook. There's a mountain of police reports that don't say the same. I wanted you to be aware of that. And again, I expect that you're going to hear from June as a victim very shortly.
Thank you, Ms. Weissenbach. Does your client wish to address this?
No.
Very well. Mr. Rakowski, anything on behalf of the people, and as stated, this is a victim's rights case.
My understanding, Ms. Van Helton would like to talk to the court.
Please.
June Van Houten.
Good morning, Ms. Van Houten. What would you like to tell the court?
I would like to actually tell the court that, yes, he might have anger issues, and it's understandable considering the past. But he is a very kind and caring person to my family, to me, to my daughter. And the fact that all you guys hear is the negative, is not all that. He is very responsible at home, and the fact that he helps out when out without even being asked to do things. He helps me with my mental status. I'm sorry. I am bipolar and schizophrenic. He helps me through that. And without him being around, it's difficult. And
Would you like to have a seat? You can have a seat if that would help.
And the fact that not having him around, it is very difficult. I'm going through a lot of problems with my ex and being around. I've already talked to the police officers about it. And even though he's in jail, he's still helping me out. And I wish that everybody would see that. Inside the letter that I put, he's helped my mother getting back and forth to doctor's appointments because she had to get surgery on her eyes. And he's also helped take my daughter back and forth to work, to school. And even, I know for a fact, even though he has problems with his wrist now, once he gets out, he's still going to help out. And I just wish that there was other ways of helping him instead of just sending him to prison or keeping him in jail.
Thank you, Ms. Benson. Appreciate it. Just to be clear, your name is spelled D-A-N, capital H-O-U-T-E. Thank you. You're awesome. Mr. Rakowski, on behalf of the people.
Your Honor, on behalf of the people, the defendant comes before you with 4 prior felonies and 4 prior misdemeanors. And I guess when I look at the pre-sentence investigation, which I believe is accurate and very complete, I think of history. History is an indicator of things. Doesn't mean that people can't change, but it is an indicator of behavior. So I look at things and I say, okay, so as a juvenile, he was involved in the system. And I understand what Ms. Weisenbach had said. Part of it was he took his mother's car, caught it on fire, jumped out of it, broke his wrist. In what we have now, he ran from the police. That would be Officer McGrath when he was told to stop, and broke his wrist. Then we have from him being assaultive as a juvenile. The court had sentenced him to 2 years, 9 months for strangulation, which is pretty significant when we talk about some of the crimes of domestic violence. Because of the strangulation, you put your hands on somebody's neck to restrict their breathing. And the court rightfully had sent him to prison for that. That's an indicator. And then we have a domestic violence third here, which, from the past, the hate crime, what he said to the people from Continental Rental. I mean, that's not acceptable at all. And then I looked at his past record from Wyoming, Michigan concerning leaving. He had cut his tether at one point in time. Here, he didn't cut his tether on the tampering. What he did was he had the V-check on his phone. He just deleted the app so that he couldn't be tracked by anybody. With all that being said, our concern really, quite frankly, is, as it was brought up earlier, he has a lot of anger issues and somebody may look at him wrong. Somebody may say something wrong. Well, the response is going to be something pretty violent. And so because of that, we asked to adopt the recommendations as they relate to the domestic violence third, as well as all the other crimes. We believe that we're at a point now where it's just protection of society. We ask you to protect society.
Thank you. Before the court is a 30-year-old man, 4 prior felonies, 4 prior misdemeanors, high school graduate, excuse me, and comes before the court with rather serious felonies. Domestic violence third, a hate crime, absconding, 2 separate counts, tampering with an electronic device, resisting obstructing. And on one hand, the court has to consider the defendant's history, his juvenile record, his upbringing, which is all part of the pre-sentence report, and to say that Mr. Cook was wrongly treated in his youth would be an understatement. It is an understatement. And as a result of that, sadly, we are the products of our environment. That is our upbringing. That is how we learn things and how we cope with things. And so the court clearly understands the prior history, and also considering the upbringing and all of that when trying to fashion an appropriate sentence. Of course, there's the other side of the story. And the old saying is basically 2 wrongs do not make a right. And clearly, Mr. Cook was wronged when he was much younger in his upbringing. And the court is aware of the sentence that was previously imposed for the strangulation conviction, which was significant, but under the facts and circumstances of the case, it was warranted. And here, the ultimate goal is if you go to prison, for instance, is that a part of rehabilitation? Do you learn from that and say, look, I just don't want to engage in this behavior again? And sure, there may be programs available within the Department of Corrections relative to rehabilitative programs. And the court, when fashioning a sentence, would strongly encourage the department to see what programs may be available for individuals like this, considering the mental health and considering the prior history and upbringing. But as I've stated, two wrongs don't make a right. And in this case, at least on the domestic violence third, as the court understands it, the defendant had killed a bird. Significant other went to tend or go to the bird. Defendant pushed the victim into a stove. Injury, police called, etc. The second case regarding a hate crime, according to the pre-sentence report. Racial statements that the defendant would shoot the victim, a dumb N, beat his A, and F him up. And when you look at the scales of justice, she's blind. She's blindfolded for a reason. It doesn't matter who you are, where you come from, whatever your background. Doesn't matter if you're Christian, Muslim, Jewish, or no faith, or you're red, green, brown, yellow, orange, does not matter. We're all human beings, and we need to treat each other that way. I think our society clearly shows that right now, that we're not doing that. And so when these statements are made to an individual who's merely doing his job, there's no justification or excuse for it. And then what happens when, basically paying the fiddler here, so to speak, defendant fails to appear, absconds, tampers with his tether device, takes the app off the phone, and then when confronted by police, resists and obstructs. I believe they found him underneath a bridge. It's where they found him at the end of the day. So clearly, one side of this is the upbringing, history, the court understands that, but on the other side is, wait a second, what's going on here? And what's going on here, sadly, is an individual that in some respects does need some help, but he has to pay piper here for the crimes he's committed, which are significant. Guideline range scores that the court has considered are appropriate. Domestic violence 19 to 57, hate crime 7 to 34, the absconding first 12 to 36, second 12 to 48, and then finally resisting and obstructing 7 to 46. Will be the sentence of this court in 7345 FH that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 4 years to 10 years. Credit for 79 days previously served. Crime victims assessment of $130 will be imposed. Attorney fees are waived. $68 in state costs will be ordered. 7386 will be the sentence of this court. Defendant be committed to the Michigan Corrections Commission, placed in their custody for a minimum of 2.5 years to 4 years. Credit for 68 days served. Restitution to Continental Rental in the amount of $3,551.37. The defendant is to execute a wage assignment to pay that if he's employed and misses 2 regularly scheduled payments. Crime victims assessment of $130. Attorney fees in all the files are waived. $68 in state costs will be ordered. 7387 will be the sentence of this court. Defendant be committed to the Michigan Corrections Commission, placed in their custody for a period of not less than 2 years to a maximum of 8 years, credit for 73 days previously served. Crime victims assessment of $130, state cost of $68. 7419, absconding on bond, second count for the second charge. Sentence will be 2 to 15 years. Credit for 66 days served with $130 to crime victims assessment and $68 in state cost. Count 2, tampering with electronic monitoring device, 365 days in the county jail, credit for 66 days previously served. $68 in state costs will be ordered. Finally, resisting obstructing a police officer. Sentence of 2 years to 15 years, credit for 66 days previously served. Restitution to Deputy McCardle, the amount of $54.79. Total restitution is going to be $643.23. And to the sheriff's office, I believe this was their damaged body cam, $588.44. That would be the Bad Axe Police Department. So $54.79 sheriff's office, $588.44 Bad Axe. Defendant is to execute a wage assignment to pay restitution if he is employed and misses 2 regularly scheduled payments. Crime victim's assessment of $130 and $68 in state costs will be ordered. All of these matters shall run concurrently with each other. My duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, the court will assign counsel form of public expense. He's to initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days. Defendant remanded in custody of the sheriff.
Okie dokie, friends. Let's stay in Michigan. Hello, Ellie. But let's go over to Judge Elmore. He's in Missaukee County this morning. Let's see what's going on there.
The case of people of the state of Michigan versus James Aldridge. This is going to be case number 26-3668 FH. Appearances from counsel, please.
Thank you, Your Honor. David Denham on behalf of the people. Robert Hertel from Mr. Aldridge, who joins me at the table, Your Honor.
All right, thank you. We are here this morning for an initial pretrial conference, but I've also been told today that there will be a plea. Here now on the court file is a copy of a written pretrial agreement and an advice of rights. I'll say, it looks like here that, well, initially it said a no contest plea, but I'm told now it's going to be a guilty plea. Looks like the defense is going to plead guilty to count 1, possession of the controlled substance methamphetamine. Count 2, assault, resist, obstruct a police officer. Count 3, which is operating with a driving license suspended, denied, or revoked, that will be dismissed. Also, count 4, operating without security, also known as insurance, that will be dismissed. And the 4th habitual felony offender enhancement will also be dismissed. Plus, there is an agreement as to sentencing that would be a jail cap pursuant to Killebrew, which would mean no more than a year in a county jail. Did I get it correct, Mr. Denham?
You did, Your Honor.
Mr. Hertel?
You did, Your Honor.
All right, Mr. Aldridge, is that how you wish to resolve today's file?
Yes, sir.
You may remain seated, but please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. All right, Mr. Aldridge. Looking back on February 11th of this year, 2026, were you on probation, parole, or bond at that time?
No.
Now, you are currently charged on the felony information that's contained here in the court file. And on that felony information, as I've already mentioned, there are 4 counts. And then in sentencing enhancement. Count 1 is the charge of possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Plus, with the 4th habitual felony offender enhancement on there, that could increase the maximum penalty from up to 10 years to up to life. However, if you plead guilty to count 1, the 4th habitual enhancement will be dismissed, and therefore you'd face the up to 10 years. Now, count 2 is a charge of assault, resist, obstruct a police officer, which is a felony punishable by up to 2 years and or up to $2,000. And with the sentence 4th habitual felony offender enhancement, that could, within the discretion of the court, increase the potential punishment from up to 2 years to up to 15 years. However, if you plead guilty also to count 2, that enhancement will be dismissed, which will mean it's only a felony punishable by up to 2 years and or $2,000. And this, Mr. Denell, and I assume that count 2, the R&O, did not involve a place of confinement at the time?
It did not, Your Honor. Very briefly, defendant left his vehicle and ran.
The reason that question is important, Mr. Aldridge, is that there could be what's called consecutive sentencing, which means whatever sentence I gave you for the possession of meth would have to be served before you could then serve the sentence for the R&O. However, because it's not in a place of confinement, such as in the jail, that doesn't apply, and they would run concurrently at the same time.
I understand.
All right, good. All right, count 3 is a charge of driving or operating a vehicle while your license is suspended, denied, or revoked. That's a misdemeanor punishable by up to 93 days and or up to $500 in fines and costs, plus vehicle immobilization. However, that will be dismissed. And lastly, count 4 is a charge of operating a vehicle without security, also known as insurance, which is a misdemeanor punishable by no more than 1 year and not less than $200, but no more than $500 in fines and costs. That count will also be dismissed. So far, is that what you understood to be your pretrial agreement?
Yes, sir.
Now, there's another part of this pretrial agreement today, and that is regarding sentencing. And that's an agreement that you have reached with the prosecutor. I don't know if I'm going to go along with it yet. I know I've seen you sometime before, but please forgive me if I don't remember everything.
It's been a while, Judge.
All right, good. Well, that's a good thing. But anyways, I don't know what I'm going to do because I don't know the full story about what everything happens. But what the agreement means is you've agreed that I would give you no more than a 1 year jail cap. Right. Means no prison, means 5 days of good conduct time. It could be 6 months, it could be 10 months, I don't know. The point is if for some reason when we come back and I don't follow it and I give you, say, a prison term, then you would have the right to withdraw your plea and come back to this stage. That's what a Killebrew agreement means. Do you understand that? All right. Now we're going to talk about potential sentencing and guideline ranges in just a minute. Now, I'm going to hold up here this pretrial agreement. I know it's a little bit of a distance, but did you, looks like you signed here on page 2. Is that correct? Did you sign there?
Yes, sir.
And before you did you go over the terms of the pretrial agreement with Mr. Hartman? Was he able to answer all your questions?
Yes.
And did he go over the evidence against you, whatever that is, the police reports, things like that?
Yes, he did.
And are you satisfied that with his representation thus far?
Yes, I am.
And you believe that so far taking this plea would be in your best interest?
Yes, sir.
All right. Maybe not the greatest thing you're going to do today on a Monday morning, but it's at least probably better than the alternatives. Do you agree? Now, if you enter these pleas of guilty today that I've discussed, you're not going to have a trial. Does that make sense?
Yes, sir.
Now, one of the other documents that the attorneys have provided to me is called an advice of rights. I'm going to hold it up here. And it appears to have your signature at the bottom. Is that your signature?
Yeah. Yeah, I have my attorney sign on my behalf. He sent me an email. I went over it with him and then, yep.
All right, so did you read through these rights before you had them signed?
Yes, I did.
And did you understand those rights that are written on this piece of paper?
Yes, I did.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you'll be forever waiving these rights as they apply to this particular case?
Yes, sir.
All right. Also, you'll be given up the right to come back to the court and claim that the plea today was a result of some kind of promise, threat, inducement not told to me today on the record. Other than the terms of this agreement that we've gone over, have there been any other promises, threats, duress, coercion that make you plead guilty?
No.
Are you doing it therefore of your own free will?
Yes, I am.
Now, I told you a moment ago that we're going to talk about Michigan sentencing guidelines. And I know you're familiar with them before, and I don't say that to be rude, but I'm just also going to say I know it looks like Mr. Hartel's talked to you about them because on this pretrial agreement that you and I talked about, it had a guideline range of 5 to 23 months. Did Mr. Hartel go over with you about
Yes, he
what's? Well, so here's what I need to make sure you understand. Sentencing guidelines are not mandatory. They are mandatory for the court to review, but what they actually provide, the minimum range, it's not mandatory, but it is something the court must use. I just want you to understand that even on this form, it says an estimated guideline range.
Right.
All right, so we don't even know. The attorneys do a really good job at trying to make it a good guess. But it takes the Department of Corrections and us coming back before we actually know what those guidelines say. Do you understand?
Yes.
Also, has anyone made any promises, threats, or any promises to you as to exactly what my sentence would be?
No.
All right, good. All right, but no matter what, if it's above that 12-month period of time, which you've reached an agreement with the prosecutor, if I were to give you 13 months or 12 months and 5 days, whatever, you'd have the right to withdraw your plea. Do you understand?
Right.
All right, good. And that doesn't mean I'm not going to go along with it, but I also don't know and I don't remember every detail. So we'll see how things go. But 12 months would be within at least that estimated guideline range. All right, Mr. Aldridge, before I take the plea, do you have any questions for me at this time?
No, sir.
All right, do you need to ask?
Everything was.
All right, good, thank you. All right, therefore, sir, asked to count 1, possession of methamphetamine. How do you plead?
Guilty.
And asked to count 2, assault, resist, obstruct a police officer. How do you plead?
Guilty.
Now, before I can accept those pleas, I need to have you tell me what you did that makes you guilty of those 2 offenses. Turning your attention back to February 11th of this year, 2026, out in Lake Township here in Missaukee County. What happened? I'm going to guess because I see a couple troopers' names listed on the witness list. Did you get stopped?
Yes, sir.
Were you?
Yeah, I was being pulled over.
Okay.
And, the risk, the obstruct, I got out of my vehicle and took off.
Took off.
Yeah, I didn't go very far, sir.
All right.
I actually came right back.
But
But I'm guilty.
it's kind of odd, in a small town, we pretty much know who everybody is, so it's pretty easy.
Right.
So let me ask a couple key questions here. When you pulled over the car, did officers or troopers turn on their lights?
Their lights weren't on yet, sir.
No, but you recognized that it was a police car?
I did recognize it was a police officer.
All right, and when you got out of the car and took off, did they say or do anything to try to get you to stop?
He wasn't that close yet, sir.
Okay, but you knew you were trying to evade him.
Definitely.
All right, and did you pass and he turn around or tell me?
Yeah, I passed and turned around.
All right, so you saw him turn around.
Yes.
All right. And, all right, and then at the time, did you have some methamphetamine in your possession or within your area of control?
Yes, I knew there was a pipe of some sort in the door of the car.
All right, so
I knew it was there and I got in the car and left with the car anyway. And I didn't think anything of it.
okay,
But I knew it was there.
all right, so hold on. What kind of car were you driving?
Yeah, it's a Dodge Avenger.
All right, so all I'm trying to do is, was that in the pipe with it had some kind of residue or extra meth inside of it? Is that right?
Yes.
Yeah, and so when you said it was in the door, was it in the driver's side door next to where you were as a driver?
Yes, it was.
Was anyone else in that vehicle?
No.
All right, so, and so did you have, in your opinion or in your mind at that time, any lawful reason to possess that amount of methamphetamine, no matter how much it was?
No, sir.
No? All right, good enough. And that was that because you had put it there sometime prior to, or?
I just received the car and I just got in the car and I opened the door and I seen it there.
Yeah.
I just
All right.
knew it was there. It was in
Okay.
it was in my possession, in my controlled space.
Okay. Probably not one of the better days or choices for you, would you agree?
That's a fact.
All right, so here's all I care about. You knowingly possessed something that had methamphetamine to some amount within it. Is that correct?
Yes, sir.
All right, good enough. Thank you. Mr. Denon, are you satisfied with the testimony provided by the defendant?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe that I've complied with Mission Control 6.302?
I do, Your Honor.
And Mr. Hartel, how about you? To all three?
All three the same, Your Honor.
All right, thank you. All right, now there's one small thing here that I'm starting to pay much more attention to. I think it's silly that somebody would go to the appellate court and argue this, but this kilo brew agreement says no more than a jail cap. That does not mean that I can't assess fines and costs and probation Would you agree, Mr. Denon?
Yes, I did not mean to apply that.
How about you, Mr. Hartel?
I would concur. In fact, if he ended up on probation, I'm sure he'd be happy, Your Honor.
Okay. All right, Mr. Aldridge, do you understand that I could give you fines and costs and probation?
I expect that, Your Honor.
All right. What happened is recently I came across an appellate decision where somebody went back and they got the Kilo Brew agreement with the jail time, but then they decided to spend lots of time and money to fight over whether or not they should be ordered to pay the $1,500 in fines and costs because it wasn't well covered in the description of the pretrial agreement. So I'm just going to make sure I cover it. So, all right, Mr. Aldridge, I don't think you would have thought that. I guarantee none of the attorneys would have thought it, but that's what happens when it's a Wednesday afternoon and I'm in the office and reading all the appellate decisions. Oh, she's giving me paperwork. I haven't even done anything. All right. So anyways, the court finds the defendant guilty of counts 1 and 2, counts 3 and 4, and the habitual enhancement will be dismissed later on at the time of the sentencing. Mr. Aldridge, we're going to come back here in about 4, maybe 5 weeks, depends how the spring rolls out, and that's when we'll do sentencing. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. And I know you've seen these before. And you're going to get a packet. You're going to complete that packet, turn it back in. You also will be subject to an interview with an agent from that office, and you have the right to have your attorney, Mr. Hartel, present during that interview. And third, within that, Mr. Hartel is going to need to make sure he gets a hold of you so he can go over that report with you. They'll probably get it about 10 days to 2 weeks prior to us coming back for sentencing. Each side has the right to come back to this court and request corrections or make objections to the content, the scoring of the guidelines, and all those things. Please keep in mind, once again, that the guidelines are not mandatory, and when it makes a recommendation as to the sentence, it is strictly that, as I am the one who makes the determination. So before you leave today, you're going to go upstairs to the probation and parole office. We have all 3 of them here today. And they'll give you that packet and schedule you the interview. I encourage you to make sure, and even though that, when was your last time you were here?
3, 4 years now.
All right. Well, they can go back and take a lot of the information from those old reports. And hopefully I didn't let something incorrect stay in there, but just because they might add some old, let's take the old report and add to it, please make sure that everything in there is up to date. Okay. I don't like passing these things forward if they're not correct. They're supposed to be correct. All right. Any objection to the continuation of bond, Mr. Denon?
No, Your Honor.
Mr. Hartel, anything further?
No, and I definitely don't object to the continuation of bond, Your Honor.
All right, thank you. Mr. Aldridge, I don't think I've seen you in a while, so that must mean that bond's going by pretty well.
Very well.
Good. Please stay on top of it. Do they have you doing any EOP or?
Yes,
counseling?
I am on.
Great.
Yeah, no problem.
Great. If you need anything further, go, and you must be going through Catholic Human Services. Just say, hey, I'd like to do some treatment. I'm not ordering you to do anything else, but if you have any other questions, I know Mr. Hartel's.
I've reached out already.
Great.
I mean, any resource I can.
Great.
Available, I'm on it.
Great. Well, they've also got a program through Addiction Treatment Services up in Traverse, where they help people provide it rurally, over the internet, things like that, through an iPhone. There are a lot of opportunities. So
Yeah, I'm at home a lot right now. Our daughter, she's on oxygen all the time, 6 treatments every 4 hours.
all right. Well, anyways, if you have any way, and there are also lots of programs online that you can do, whether they're apps that do reminders, things like that. So I encourage you to make some good choices there. All right. Thank you very much. We are adjourned.
Good morning once again, everybody. TCF Live. It's Monday, the Monday after Easter. Good to have you all here. Speaking of which, lots of new people I think are out there given the stats I'm seeing right now. So if you're new to the channel, please do say good morning in the chat over on the YouTube side. Have a tremendous community there. Everybody's very friendly. So announce yourself, say good morning. And welcome to those of you watching us over on Substack. This is our first day streaming on Substack. Barbara dropped a link a little while back in the YouTube chat. If you're not subbed to us over on Substack, please do so. Because we're going to be posting a lot of stuff over there as time goes on. Okie dokie, let's go. Let's go to Texas. Judge Stevens.
Hey. Did you want to get it over? No. Did you need? It says defensive.
It says email to your.
You didn't get there where she said she doesn't want to do probation? Just wants their time to get over it. You don't want to do probation. What she said?
But is she, of course, happy to.
Yeah. Yeah, 12 months while she.
All right, we now call two cases. Clause numbers 21-36529 and 21-36760. The state of Texas, is it Averiana? Beverly. A lot of syllables in there. And you were charged with burglary of a building and theft. And each of these cases. Well, hold on. You're on probation on each of these, right? And so we have first amended motions to revoke probation that have been filed in each of these cases. The defendant pleaded true last month to allegation 1 and allegation 2 in each case of the first amended motions to revoke probation. That is committing the offense of unlawful carrying of a possession, carrying a weapon, lawful carrying of a weapon on or about August 5th of last year. And also on that day, committing the offense of illegal possession of a controlled substance on or about August 5th, 2025. Each of those are violations of probation. Actually, condition 1, don't commit a crime. True. Good call. No.
While we're waiting on Judge Barbara, thank you for the $10. Happy Monday to you as well. I appreciate you.
What? You kind of read probable cause, David, which is unreasonable, unreadable. It's unreadable.
The new one?
Well, the one is related to this August 5th incident. And the controlled substance, I can't, what is it?
Is that a better copy? Or do you got the same guy?
No.
Yeah, mine's a little bigger.
Can you read it? What is the drug? I can't.
There were several.
There was 1, 2, 3, 4, 5 drugs.
Yes.
Let's see oxycodone in here. Marijuana. At the same.
Yeah, I think the one you were looking at was the December of 2025. That's the one I reading.
No, I've got August 5th.
Well, that's one I just gave it.
Which is what we're talking about.
Yes, sir.
Anzalone. See, hold on. Okay. Wasn't there. What drug was not present? Earlier, the defendant entered pleas of truth to 2 First Amendment motions to revoke probation. The defendant is looking at a state jail felony. Punished as though it were a 3rd-degree felony, correct?
No.
No, it's
It's just
state jail.
It's just state jail. We'll get a cap for 1 year
Yeah.
Okay. And capital.
or 12 months. but I need to-
Okay. Go ahead. State first and last.
Judge, I think I'll be looking at her history and looking at the updated pre-sentence report. We've done everything we can to try to get her on the right track, and she just keeps committing crimes. So we'd ask for the 1 year state jail.
Go ahead. State and defense.
Your Honor, as you look at Miss Beverly, she's a young lady. Probably has some growing up to do. Especially from her response to the probation department. In reference not seeing the big picture on this. The only saving grace on this, judge, is
Right.
that if she goes to the state jail, maybe she'll see the light of day and be able to get help in the state jail. Safe P would be an option for her when she's incarcerated. When she gets there and then sees the environment and people there, she may have a change of heart. It is my understanding that probation has offered everything that they can to her, but she wants to, but doesn't want to take advantage of it.
Let me ask you, how much is still remaining on restitution? If any, it was $6,000 originally.
Actually, between the 2 cases, I think it was 8,500.
Balances,
Sir? It hasn't, none of it has been paid?
no, sir.
So you got 6,000 in one case and then 2,500 in the other.
Yes.
What about that?
Judge, she keeps committing other crimes. It's not like she's paying off restitution. What am I supposed to do? Just say, well, do it.
I'm asking you.
I understand.
Does that
but I-
factor in? She's got 121 days, correct?
Yes, sir.
What do you have to say, if anything? Nothing? I'm sorry, I can't.
I do have something to say.
I can't hear you, sweet.
Speak up. I did make payments in my restitution.
Did you?
And
That's not what we're showing though. What probation would know. I'm not seeing any, but
in the other,
has he paid? She's not paid any on restitution in these 2 cases?
Looks like none of it has went towards restitution.
None of it. I guess you're paying fees or something. It goes there, but it's not going to restitution.
it's doing the best I could to pay the restitution.
Ma'am?
I was doing the best I could to pay the restitution. So, all right.
From probation, anything you want to add?
No, sir, with the 13 new alleged offenses, it's revocation. It's the best thing I'll say.
Yeah. 13 new. It's tough.
Well, that's what I'm saying, Jim, maybe when she gets there, these programs that are offered there, you can take advantage of it. But we straighten out, before she gets out.
With all these cases coming down the pike, I don't know.
Oh, that's good.
They're gonna have a bunch of them, but she's gonna have to pay for all those and do that.
If nothing further, I'm going to find that there is sufficient evidence supporting these first amended motions to revoke probation. Well, first of all, the pre-sentence reports are made a part of the record in each of these two cases without objection. And in each of these first amended motions to revoke unadjudicated probation, the defendant has pleaded guilty or true to allegations 1 and 2, voluntarily, knowingly, intelligently, and based upon discussions with her attorney. And that is enough to grant these first amended motions to revoke unadjudicated probation by preponderance of the evidence or greater, as I find allegations 1 and 2 in each of these cases to be true. Thus, your further unadjudicated probations in each of these cases are hereby revoked. Earlier in these cases, you pleaded guilty to each of these state jail felonies voluntarily. When I placed you on probation, you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these two cases. And you were hereby sentenced. The cap was 1 year, I believe, in the agreement. You were hereby sentenced to confinement in the state jail for a term of 1 year. You will be given credit for time you've served, which looks like it's about 4 months. Also, the judgments in each of these cases shall reflect that restitution in the amount of $6,000 is part of the judgment in 21-36529, and $2,500 restitution will be part of the judgment in 21-367602 to be paid to the complainants in each of those two cases. They are named in the indictment in each of these cases. Anything else?
No. Everything's good.
Yeah.
All right, I'll keep an eye on Judge Stevens' court, but let's go to Louisiana. They were off last week, so let's see what's going on with the board.
Can you hear us? All right, good morning. The Pardon Board is now at the Louisiana Correctional Institute for Women on Monday, April 6, 2026. Good morning, Warden. Would you and your staff introduce yourselves, please?
Morning, Kristen Thomas, Warden.
Afton Gaddy, ARDC Supervisor. Camilla Hudson, ARDC Supervisor.
Avery Nolan, Student Attorney.
Stanislav Moroz, Supervising Attorney.
All right, thank you. And let me just go ahead and introduce the other folks that are there at LCIW. We have Brandon Matthews. Brandon, where are you?
Right here.
Yes, sir, okay. And Dr. Brad McConville is on Zoom. At LCIW, Avery Nolan, who has introduced herself. Mr. Blake is on Zoom with the Parole Project. Also there at LCIW, Candace Matthews, Ms. Cobb's daughter. Granddaughter, I can't say Ms. Lloyd's first name. Ms. Cobbs, could you pronounce it for me, please?
Hajane.
Hajane. Okay, thank you. And then I don't know, has Brad made it there yet? I have another list here, student attorney with the name Brad McConville, but that's the psychiatrist, I believe. I'm sorry.
That's correct.
Okay, and let's see, Brandon Matthews Jr. is here with us in Baton Rouge. Farrah Addison is also here with us in Baton Rouge. Emily Baker and Carolyn Leckwich is also here. All of those folks are here in support of Ms. Cobb's application. Here, also, we do have opposition on Zoom. We have Brant Hardy, Sterling Core, Liz Core, Jason Core, who is victim's family but does indicate support, Terry Cobbs, here at headquarters, Mr. John Sinkfield with the AG's office. And on Zoom, we have from the DA's office in East Baton Rouge Parish, Miss Tracy Barbera. So Ms. Cobbs, before we get started, would you introduce yourself to us, please? Tell us your name and DOC number.
My name is Carolyn Cobbs, number 100118.
And so your counsel has introduced themselves, but I'd like for the record for them to reintroduce themselves, please.
Oh, I apologize. This is, well, Avery, do you want to introduce yourself?
I'm Avery Nolan, a student attorney with the Tulane Law School Domestic Violence Clinic.
And board chair, my name is Stanislav Moroz. I won't be speaking. I'm just here to supervise Ms. Nolan. And I just did want to clarify, did you say that Mr. Jason Core was present in Baton Rouge? Is that correct?
He's on Zoom.
He's on Zoom. Okay. I didn't see his screen pop up yet. So I just wanted to make sure the board had that because he will be one of the speakers in support.
Okay. Do you have him on Zoom?
He's at the bottom.
Stand by, we're checking.
Thank you so much.
He's trying to call him. So while we're trying to get in touch with him, I'm gonna just read some identifiers into the record and explain why we're here again today. So Ms. Cobbs, you're here because you submitted an application for commutation of your sentence. You were sentenced to East Baton Rouge Parish, October of 1982. You're serving a life sentence, second-degree murder. Is that correct?
Who? Yes, ma'am.
So we are here. You had a hearing in August of last year, August 2025. And at that time, since that hearing, we've rescheduled another hearing for you because there was an error that was made. All of your speakers who had signed up to speak in support were not allowed to speak. That it was brought to our attention that could have been a violation of the public meetings law based on our own rules. So we've scheduled you for a new hearing today, and that's why we're here. Your case has been assigned to Mr. Prater. He's going to have some questions for you, and then we'll hear from the folks that want to speak in support and those who want to speak in opposition, and then we'll have an interview of sorts after your attorney gives us their presentation. So you ready?
Yes, ma'am.
Okay, thank you. Ms. Cobb, good morning.
Good morning.
I seem like I just talked to you.
Yes, sir. It's been a couple of months.
But I've read the case once again, and I've listened to your video once again, and or this time, and I really I want you to. I don't really think we need to go over the entire case again, but I want to turn it over to you as quickly as I can for you to try to convince us, all four of us, why you think that you're deserving of this commutation of your sentence and eligibility for parole. I want to give you another chance, and I promise you, I voted against you last time, and I want to assure you I have a completely open mind, and so I want you to try to convince the board that you've done everything necessary to earn this second chance. And I want to turn it over to you, and then I want to hear from the warden, see if there's been any changes, and I want to hear her present her case again about the kind of person that you've been since you've been incarcerated under her tutelage. Okay, go ahead. I'm ready. I said all that to try to get you to not be nervous, okay?
Well, sir, after spending 7 years in an abusive marriage, I decided to get a divorce. And I decided to hire Mr. George Emmett Court to get that divorce. And when time came for us to go to court to settle the divorce, the judge said that permanent custody and control of my children had been given to my ex-husband. Sir, I was shocked at this turn of events. And so I was shocked and confused that my husband could be given and ended up with protection, custody, and control of our children. And he did not even attend a hearing. Neither did he have representation from an attorney. So I went to get my divorce. I got my divorce. And I also went about trying to get someone to help me to get my children back. I went from law office to law office trying to get help to get my children back. And so I ran across this attorney who told me that for $500 that he would be able to help me get my children back. And so I paid him $500, but he did no work. He did nothing. And so I got my money back. Finally, I went and I ran across this one attorney who told me that once a decision has been made concerning custody of children, that it is almost never reversed. And so upon hearing this, sir, I was discouraged and I became very disturbed. My world had come to an end. All hope was gone. I was confused and in tormented by the things that took place. I went to confront Mr. Core to ask some questions. I shot Mr. Core. I panicked and I ran from the office. And I am sorry for shooting Mr. Core. I'm sorry that I let my emotions get the better of me. Mr. Coors and Miss Carter, I cannot imagine how you must have felt upon hearing of the death of your father and your brother.
Speak to the board, okay?
Your world, just say, they don't want you to address them directly, so just say, I'm so sorry for their loss, as opposed to you.
Sorry. I'm sorry that I took Mr. Core's life. I'm sorry that I just let my emotions get the better of me. I was not myself.
All right. Thank you, ma'am. That coupled with what you said in the video and with what you said at the first hearing, I think that's what I wanted to hear. Warden, So let's see, Ms. Cobb, before I finish, Ms. Cobb, is that all? I didn't interrupt you in your statement. Huh?
No, sir.
Okay. All right, well, we'll get into a little bit more with you in a little bit when the board has a chance to ask some questions. Warden, would you tell us about Ms. Cobb and her behavior since you've seen her and since you've been
Yes,
with her?
sir. Ms. Cobb lives in our assisted living dormitory. So she's not, out there working every day, but she does do housekeeping and whatnot in the housing unit. She has not had a write-up since 2020. So the entire time I've been at LCIW, I've not had any issues with her, seen any issues with her. She is low risk and low needs. I know that Mr. Blake is on, so he'll probably speak to parole project and any transition plan issues, but she is a minimum custody inmate. And like I said, she had, in the past completed various CTE classes and things of that nature, but she is in our assisted living housing unit now.
Okay, thank you, Warden. We appreciate that very much. And now we'll move on to those that will be speaking in support. And then we will speak to those that are in opposition to this request. And so we'll begin. Let's see. Okay, gotcha. Okay, let me look at my notes here to make sure we don't miss anything. Mr. Brandon Matthews, who is at LCIW, and I believe that is your son. And so we'd like to hear from him. Mr. Matthews?
Good morning. Good morning to the honorable members of the board and the family and friends of Mr. Emmett. My name is Brandon Matthews. I am Carolyn Cobbs' son. I'm here today to respectfully ask for mercy. My mother is 71 years old and she has grown older and has health issues, and they have grown too. And she has begun to struggle with comprehension and memory. My greatest wish in life is to spend a little time with her before long, something that I've not done since I was a little boy. At the time of the tragedy, I was 7 years old. Before my parents got divorced, my mom did her best for us. She was loving and caring, but I also witnessed difficult relationship with my mother and my father. My father was very violent to my mother. I remember him smacking her around a little bit, hitting her in the face and screaming at her at various times. I remember being very scared and confused. When they got a divorce, my father would let my mom see us, wouldn't let her see us for months. This was deeply painful for me and my sister. And I never imagined my mom would end up committing such a horrible crime, but she did. And over the years, we talked about this and the turmoil she was experiencing. In no way this excuses what she did. Even while in prison, my mom has been very influential in our lives, teaching us the importance of serving our country and gaining an education. She is the key reason why I'm an Army veteran today. My daughter is an Army veteran, and my son is currently serving United States active duty Army right now. And my sister also works for the fire department. When my sister was diagnosed with a rare form of blood cancer, my mom researched some foods my sister could eat during her treatment and called her every day before her chemo session. Over the years, we have had many long talks what my mom had done to a family that she didn't know, and she has instead she should have gotten some type of mental counseling. We would often talk about Mr. Court's family and what they must have gone through, and how much she wished she could express her remorse to them. I had the opportunity to meet Mr. Court's son, who I truly believe is a very wonderful and beautiful human being. I had the chance to hug him and ask him to forgive my mom and our family for the tragic harm that my mom caused in his life. I've also heard Mr. Court's brother express the pain that he went through because of my mom and how he thinks about his brother every day. And I also think about him every day I took those words to heart. Regardless of how any member of the court's family feel about my mother's release, I'm very sorry for their pain and will always hold them in my heart. In closing, my mom means the world to me. I know she's not entitled to forgiveness or to clemency, but I humbly ask the board to consider letting me and my family take care of her for the remaining years outside prison walls. Thank you for your time and consideration.
Thank you, Mr. Matthews. We'll take those words under consideration and appreciate that. The next up is Dr. McConville. Dr. Brad McConville will be speaking from Zoom or on Zoom. Doctor, would you tell us what you have to say, please, sir?
Sure. Thank you for giving me the opportunity to speak today. My name is Brad McConville. I'm in board certified internal medicine, psychiatry, and forensic psychiatry. I work for Tulane School of Medicine, but I also work for the State Forensic Hospital in Jackson. And I do risk assessments for patients. So I think a lot about the relationship between mental illness and violence and recidivism, as I have to advise courts frequently on those issues. So I had the opportunity to evaluate Ms. Cobbs last summer for the first time and then reevaluated her last week. And from a psychiatric perspective, she suffers from major depressive disorder and chronic anxiety. These are conditions that have been seemingly well treated for a number of years now. She does have mild memory impairment that I was able to determine, but she has responded to treatment. I think that she was, in my evaluations of her, cooperative, thoughtful. She has good insight. She told me about the circumstances surrounding the offense, and she did express, I thought, some sincere remorse. It was evident based on, her history and my experience talking about trauma and stressors that lead to behavior, that she was experiencing really severe psychological distress at the time of the offense in question. But then looking at her actual risk factors for future violence, I think that she is an exceptionally low risk category, and I'll explain why. So she is, female, lower risk. She's elderly. She doesn't have a significant substance issue. She doesn't have any personality disorders. She had no criminal history prior to this offense. And then not only does she have sort of an absence of those really significant clinical risk factors, but she also has a number of protective factors. Surprisingly, she's remained in very strong and sustained support from her family, her children and grandchildren. She's been engaged in work, and I believe that she has gone through rehabilitation and developed a lot of effective coping skills that she didn't have prior to this long period of incarceration. And I think importantly, she has a clear and structured recovery and reentry plan to work with the parole project. So from forensic psychiatric perspective, I think that there's no evidence to suggest that Ms. Cobbs poses a meaningful risk to public safety if released under these structured parole conditions. I've looked at some research indicating that she's in a very low risk category. So in closing, I would like to respectfully submit that Ms. Cobbs meets the criteria for clemency consideration based on her low risk of recidivism, strong protective factors, documented rehabilitation, and a structured supportive release plan. Thank you very much for your time and consideration.
All right, thank you, Dr. McConville. It's very concise, and we appreciate you being on Zoom with us. Okay, let's see. I think the next one to speak is going to be Jason. Let's see, Sterling Core.
Jason for the.
Please go, Jason.
Jason.
Please go,
It's
Jason.
Jason,
Yeah.
okay, Jason Core. Green. Okay, Jason Core. Mr. Core,
Mr.
you
Core is
with
on
us?
mute. Yep.
Thank you.
Okay, there you go.
Hi, I'm Jason Core. I'm here today to humbly and earnestly request clemency for Carolyn Cobbs. This is not a request made lightly, nor it is one meant to overlook the gravity of her past actions. Instead, it is an appeal to recognize the extraordinary growth, transformation, and humanity that she has demonstrated during her years of incarceration, and the healing and closure her clemency means to me, the son of the victim, George Emmett Core in this case. Since Ms. Cobb's last hearing, my aunt and father's sister, Diane Carter, wrote a letter in support of Ms. Cobb's clemency. In that letter, she wrote, "I believe that Ms. Cobbs is remorseful for what she did. It is time for healing and forgiveness." And I share my aunt's sentiments completely. In my view of justice, I need to believe in the concept of paying one's debt to society. And I feel she has paid her debt. And Ms. Cobbs now longs for the chance to reunite with her beautiful family and give back to her community in meaningful ways. I want to help facilitate that. I met with Brandon and Candace, her lovely son and daughter, and I saw so much of myself in them, and we had quite a lot in common. They see in her not only a mother, but a source of guidance, love, and stability that their lives have been missing. Granting Ms. Cobbs clemency would not only restore her freedom, but it would also strengthen a family that has long awaited her return. This is a gift I would be proud to help provide. I ask you to consider the full measure of Ms. Cobbs' humanity, the struggle she has overcome, the positive changes she has made, and the hope she now carries for the future. Clemency is an act of justice tempered with compassion, and Ms. Cobbs has shown through her actions, her words, and her unwavering commitment to growth that she is worthy of this mercy. I believe that continuing to keep her in prison does not serve justice any further. She has been punished, she has paid her debt, and she has used her time to truly transform. I don't feel she would pose any threat to anyone if released. Granting her clemency would not erase what happened, but it would recognize the humanity in her and the possibility of redemption. It would also allow me, as the son of the man she harmed, to show that forgiveness is healing. Holding on to anger alone does not heal. Forgiving Ms. Cobbs is a means of closure to me and will allow me to bring a measure of positivity back into the world. My mother, Carolyn Leftwich, is also in person at this hearing and staunchly advocates for Ms. Cobbs' release, having also written a letter to this effect on her behalf. And so for these reasons, I respectfully ask you to grant clemency to Carolyn Cobbs so that she may step forward into the next chapter of her life, not as a prisoner defined by her past, but as a woman who has paid her debt, ready to contribute, and eager to live out her remaining years in service to her family and her community. I appreciate your time, your consideration, and your commitment to justice. Thank you.
Mr. Court, thank you very much for those words, and we appreciate you being on Zoom with us today. Okay, I think that if I'm not mistaken, and I'll ask somebody to bring my attention, we'll turn it over to Avery Nolan. Is that correct, Mr. Moraz?
Yes, sir. Thank you.
Okay, all right. Just want to make sure we're all in one accord here. Avery Nolan, would you speak to us, please?
Yes, sir. Good morning. My name is Avery Nolan, and I'm a student attorney with the Tulane Law School Domestic Violence Clinic. Thank you for your time and consideration today and for hearing Ms. Cobbs' case. We understand the board heard Ms. Cobbs' case last year, so we would like to first focus on what is different today, including additional support from the victim's family and critical information the board learned from Ms. Cobbs' son, Brandon, about his parents' relationship. At age 10, Jason Core lost his father when Ms. Cobbs committed a horrible crime. At ages 7 and 5, Brandon and Candace Matthews lost their mother's physical presence in their lives when she was arrested and incarcerated for this crime. It has now been over 43 years since the tragedy that transformed the lives of these children. Jason Core already spoke in favor of Ms. Cobbs at her last hearing, but since then, he, Brandon, and Candace met for the first time. They bonded over their shared love of music, the pain they suffered growing up without one of their parents, and their journeys toward healing and forgiveness. Today, they are united in asking this board to recommend Ms. Cobbs' release. Also, since the last hearing, the victim's sister was so moved by her nephew's ability to find forgiveness that she too has decided to support Ms. Cobbs' release. We recognize there is no one way to respond to or heal from a horrible crime, but we believe that it is a testament to forgiveness and mercy and a testament to Ms. Cobbs' growth in prison that the victim's son and sister are not just expressing a lack of opposition to Ms. Cobbs' release, but that for them, it's an essential part of their healing. In addition to the strength and support for Ms. Cobbs' release, we would like to address the circumstances of Ms. Cobbs' life leading up to the crime, some of which the board heard for the first time from her son today. Ms. Cobbs married an older boyfriend right after high school and later became the mother of 2 children she absolutely adored. She hoped for a loving and respectful marriage, but that was not her reality. Her reality was that her husband would beat her when she did not live up to his expectations, like when dinner wasn't ready when he would get home from work. Ms. Cobbs' son, Brandon, has vivid memories of this abuse. Ms. Cobbs eventually sought a divorce, but her husband, who had abused her for years, ended up being awarded custody of her children, despite the fact that he'd never shown up to court to contest the divorce. Ms. Cobbs was confused and distraught. After the divorce, even though she had visitation rights, her ex-husband would not allow her to see her children. One time when she tried to see them, he struck her in the face, just like he did when they were married. The Christmas after the divorce, Ms. Cobbs bought presents for her children, but he prevented the kids from seeing her. He tried to erase Ms. Cobbs from her children's lives and soon married another woman, Patricia Matthews, who he abused as well. Ms. Matthews explains all this in her letter of support for Ms. Cobbs. Ms. Cobbs missed her children dearly and was desperate to get them back. She went to lawyer after lawyer after lawyer. One lawyer took what little money she had and did no work in her case, while another told her that she had no chance of getting her kids back. All of this, the abuse from her ex-husband, the confusing loss of her children, and the frustrating experiences of trying to get her children back, caused Ms. Cobbs to feel like her world was falling apart and led her to a mental breakdown. Ms. Cobbs went to Mr. Court's office to try to understand how this had happened, and in the several minutes she was in his office, she completely lost it and committed a horrible, inexcusable crime, shooting him. And for that, she is deeply remorseful. Of course, none of this excuses Ms. Cobbs' actions, but it does provide context about how a hardworking mother of two, who had never been arrested before, ended up committing this crime. In the 43 plus years since Ms. Cobbs has been in prison, she has done everything in her power to atone for her crime. I won't repeat all of her accomplishments in prison since the board already has her information, but she did engage in mental health counseling, completed critical programming such as Thinking for a Change and Victim Impact, deepened her faith, and was on the dean's list for a prison college program. Despite decades of incarceration, Ms. Cobbs has always stayed committed to her family. When her children were younger, she played dominoes with them to help improve their math skills and help them through telephone homework sessions. She encouraged her son to join the military so he could serve something greater than himself. And when her daughter was diagnosed with a rare type of blood cancer, she researched treatment options and healthy foods for her to eat. Ms. Cobbs' dedication to motherhood and the success of her children, even from behind bars, touched the victim's sister's heart and is one of the reasons she supports her clemency today. It is also worth mentioning Ms. Cobbs was convicted by a non-unanimous jury, and the Louisiana Supreme Court has stated that clemency is an appropriate remedy for non-unanimous jury convictions. If released, Ms. Cobbs would have the guidance and support of the Parole Project, her loving family, and the Beacon Light Church in Baton Rouge. She hopes to volunteer at a food bank and to bring all the Guard magazine clippings that she sent to her son over the years in her letters to life by helping him tend to his garden. As one of her grandsons stated in his letter of support, my grandmother is elderly and she has seen more days than she has ahead of her. After spending 43 years incarcerated, Ms. Cobbs is now 71 years old. She is one of the longest serving women in Louisiana prisons and lives in the assisted living area. She is also a trustee in the prison. This is the only crime she has committed, and as Dr. McConville stated, she is not a risk to society. We recognize that not every member of the Core family supports Ms. Cobbs' release, but we believe the connection made between the children of this tragedy and the victim's sister support are a testament to Ms. Cobbs' remorse and accountability for her actions and deserves this board's consideration. We humbly ask the board recommend a commutation to a term of years. Thank you again for your time and consideration today.
Thank you, ma'am. I appreciate those words. Well spoken. And if I'm not mistaken, I believe that is all that will be speaking in favor of Ms. Cobb's request. Now we'll move on to those in opposition, and we will start with Sterling Core, who is in opposition. Mr. Core, are you with us? Sterling?
I am, and can you hear me?
Yes, sir.
I believe I'd like to have a different order. I would like to go last because Terry Hessick is there, his law partner, I believe. He signed in.
No, sir. We're gonna allow Mr. Hessick and then the Attorney General and the DA's office to close out. So you can go ahead and make your comments now.
Okay, fine. That means Brant Hardy, who is on Zoom, will not be speaking on my behalf. He's a counselor, much like McConnell Bob, and he was going to actually make a case for the opposite of what their analyst said. Okay, let me go ahead and say, first of all, I hope everybody had a happy Easter. I am blown away by the pretty picture you all you all paint for Mrs. Cobbs. There's only 3 people or 4 people in that room right now that has as much history as I and Mrs. Cobbs have, and that is Mr. Hessick and Mr. Sinkfield. I have been the face of opposition on this for 40-something years. But before I get into that, let me just read, and I apologize, I'm extremely emotional and stressed out over this. Again, my name is Sterling Core. I'm the younger brother of the murdered victim, Emmett Core Jr. He was a prominent local attorney and also ran for sheriff. Our faces are covered because we're sincerely afraid for our safety. I don't care what any analyst has to say. You can't guarantee that this person is not going to hurt again, just like they hurt 40-something years ago. I like to remind the board that Hiller Moore was a detective on this case, and John Sinkfield was the prosecutor. Both are in strong no commutation opinion, and Mr. Sinkfield wrote a very heartfelt letter to the board. Brandon, I do thank you for your kind words. We've met before, and you definitely said 20 years ago that you wouldn't be the man you are today if we hadn't been keeping your mother in prison. You have a change of heart, and that's your opinion. My nephew, Jason, who I have a good relationship with, as I have a good relationship with my sister, has less to gain from this decision than I have to lose, for I have a larger footprint of responsibility. He is speaking for one family member, for he has never married nor has children. I, on the other hand, have been married for 35 years with multiple children to protect. Excuse me, and the legacy of my brother and my parents to honor. Like my nephew, my sister has never been involved, does not reside in Baton Rouge. She moved several years after the murder to a Midwestern state. I won't name the state because I don't want to reveal too much. And she has been there for over 40 years, and she doesn't frequent Louisiana very much. I reside in this parish. I have no plans on leaving. So basically, they have less skin in the game than I do. And that's their opinion if they want to push this agenda. But anyway, so from a family perspective, my wife and my deceased mother and myself are the faces of the local opposition. So please take that into consideration. Let me also say, before I get into the heart of my letter, that I am heartbroken and feel a tremendous grief, not only for my family, but just as sincere for hers. We are all victims here, and I mean that. Let me catch my... Releasing her into the general public will not end our grief. This forum is not about opinion as much as it is about facts. And feeling a certain way and having her stay in prison or get out of prison is not going to make your grief go away. This is about facts, not feelings. So with that said, and on behalf of my family, we beg this board to deny Mrs. Cobbs commutation for the following reasons. And the reasons I'm getting ready to read is the truth, and it has nothing to do with the pretty painted picture that their side presented. Number one, and the main one, not what my family was promised. We took the death penalty off the table to have life imprisonment without parole. She needs to pay her debt to society. Number two, crime is out of control, and releasing inmates early is not a deterrent. The rule of law is maybe modern man's greatest achievement. The law is too important to be toyed with. Her actions must have consequences. Number three, the level of premeditation was extremely calculated. She was obviously banned from seeing my brother after the custody case. So she planned the murder carefully by making an appointment while a temporary secretary was on duty. She used an assumed name. She was disguised. She filled out paperwork. Old clients don't fill out paperwork, you know. She, again, was there when a temporary secretary was there. She entered my brother's office and shot him in the chest. She then fled to an awaiting car, like she said. She had plenty of time to change her mind. The time span from when she lost custody to the murder was I believe, many months. It could have been 6 months, but it wasn't hours. It was, she had plenty of time to reconsider and to calm down and take a different direction. Number 4, she had a hit list of other attorneys to harm. That should say it all right there. What does that say about her plans? And number 5, Mrs. Cobbs never gave up the 38 caliber handgun. This should be a big red flag too. Number 6, she has been untruthful, misleading, and dishonest in describing the details on the day of the murder. She has always painted a picture of a woman that needed a shoulder to cry on and sauntered into my brother's office for help. This could not be further from the truth. She didn't saunter. She was not allowed. She's painting a picture that just doesn't represent reality. One thing I've learned from watching past Pardon Board YouTubes is if you want leniency, you must speak the truth. This to me tells so much of her mental state by being unwilling to own up to her crimes. It is a false reality complex. Number 7, let's not make time an issue. We are only a few years apart and we both have plenty of time left to live. Murder seems like yesterday to me. And Brandon thinks about it all the time, and I think about it every single day. Number 8, the number and type of write-ups are staggering. 121. Don't tell me she's been a model inmate, okay? And which I just heard a moment ago. Number 9, no remorse. Today, you could tell she was a little better coached. Didn't you notice her attorney lean over and say something? So she said she was sorry today twice. In the past, she has shown no remorse and at times acted maniacal. The biggest reveal at the last hearing was a question the Pardon Board asked her, are you remorseful for your actions? She replied in a very strong, clear voice, no, I would do it all over again. He had it coming. He had it coming. That statement alone says it all. Number 10, this hearing is a result of a loophole of sort from Act 122. I know you people know about this. This hearing is not in the spirit of that law. It is for juveniles who have committed crimes with very long sentences. She was not a 60-year-old teenager hopped up on hormones, but a 28-year-old grown woman with a 5 and a 7-year-old. Commuting this case is just a hop, skip, and a jump to a parole. And I know y'all know this, so please use your wisdom here and don't go that direction. Number 11, and this is where I want some more dialogue. I'm almost done.
Time out. How many numbers do you have on your list?
121. One more. I'll be brief. Okay. Number 11, from the evidence shared at the last hearing, more needs to be revealed about her schizophrenia. That was brought up at the last hearing, her depression diagnosis and anxiety. So in closing, her sentence was determined by a grand jury and a jury of her peers. She is by no means rehabilitated. No matter what y'all are saying over there, you will not convince me she is ready for the outside. She never will be. Is it wise? Is it wise to unleash someone onto our committee that has lied and misled the board, who has a confused perception of reality, who has a pathetic inmate behavioral record, who has committed a very heinous, cold-blooded, premeditated murder, and most importantly, and this is the critical one, the repeat potential to harm herself and others by way of maybe some mental shortcomings? I say it's not worth the risk, and I hope you agree. Wouldn't it be more beneficial and compassionate to her to let her remain in prison and get the care she needs and the peace of mind we deserve? Thank you.
Okay. Thank you, Mr. Core. We appreciate those words, and we'll take those into serious consideration. I believe the next is Terry Hessig. Is that correct? Mr. Terry Hessig, victim's friend in opposition. Oh, there you are. Thought you were going to be on Zoom. Thank you, Mr. Hessig.
I'm Terry Hessig. Emmett Ford, the victim, was my law partner and my very good friend. Emmett was 39 when he was murdered by this woman. I managed to reach a ripe old age of 80 years old. Emmett never got that chance. He did represent Carolyn Cobbs in a divorce proceeding. She lost custody of her minor children at that proceeding. But I have some unfortunate truths to give you which do not comport with what Mrs. Cobbs has told you. She lost custody of her children and essentially agreed to transfer of custody because she knew she stood no chance of keeping custody during that proceeding. For the main reason that she had been working as a prostitute. That's the kind of home, if you want to call it that, she would present to those children. Some other facts that Sterling has gone over briefly that I want to call to your attention again. Ms. Cobbs said she went to several attorneys to get no relief as far as custody. There has to be a reason for that. Also, she's claiming that she went to Mr. Ford to find out what had happened, possibly to get advice, possibly to get counseling. But here's what really happened. When Carolyn Cobbs called to make her appointment, she gave a false name, pretending to be a new client. When Carolyn Cobbs entered our offices, she wore a disguise, a wig, and dark sunglasses. And when our secretary sat down with her, all new clients fill out a form which gives basic information, their name, their address, their children, their spouse's name and address, their dates of birth, those kinds of things which we need in order to effectively file pleadings for our clients. She sat there with the secretary and gave false name, a false address, and unfortunately for her, she did have some information on there which was truthful, like her date of birth and the children's names, which eventually was how she was caught. But she gave false information while wearing a disguise. She went into Emmett Ford's office, pulled a gun out of the purse and shot him in the heart. She never came to that office to get advice or to get counseling. She came to our offices with the premeditation to kill Emmett Ford. That's the only reason she was there. And she succeeded, and the jury of her peers found her guilty of second-degree murder. Second-degree murder carries a life sentence without probation or parole. She should be made to carry out the sentence. The state and the jury of her peers told her she had to serve. I am not convinced that this woman has ever been remorseful. Frankly, I am in fear for myself and the family, and for Mr. Ford's family, and for Sterling and his wife and their children. This woman is allowed to roam the streets again, brood over the people like myself who have kept her in prison all these years. She apparently has been doing fairly well in prison. She's been getting psychiatric and psychological help. The warden thinks she's a good prisoner, and that, frankly, is where she should stay for the remainder of her years. Thank you.
Thank you, sir. We appreciate your words. All right, we will hear now from Mr. John Singfield. With the Attorney General's office.
Honorable Commission, John St. Phil, I'm currently executive counsel for the Attorney General of Elmore. Formerly, I was Chief Deputy Attorney General to Governor Jeff Landry, and before that, Senior Counsel Jeff Landry for 8 years. Spent 11 years under O.C. Brown, prosecuting cases and being Chief Deputy district attorney late in my career, and I came back to that 6 years as first assistant DA for Richard I. Ubo, County Chief Parish before he became Attorney General. And I served 17 years as first assistant DA at the Elmore. Until I moved over to the Attorney General's office as first assistant Attorney General. I give that background because I have some disagreement with some of the stuff that's said. I tried Carolyn Cobbs, and what I saw, which is rare, I've been prosecuting murder cases over 50 years in the state. And y'all see a lot of them. There's a lot of drug murders that are premeditated. I tried Derek Todd Lee, gave him the death penalty. He had a lot of premeditated murders, so they are. But one like this stands out to me because I was very close by, and there was still wet blood all over this whole scene. I was at the crime scene in probably a few minutes after it happened. I don't know if I beat the coroner there or not. Well, what was very plain here is I hear all this about her being upset and emotion involved. I hear the psychiatrist. I would love to cross-examine him, but sometimes they don't hold up so well when they face cross-examination by an experienced prosecutor. But one thing here that was said was wrong is when I guess the son said she feels she has paid her debt to society. When you do a premeditated murder, and you take your time, which she did, and she made a decision that another human being was going to die that day. And she disguised her house. I'll defer to the record. I haven't viewed the record. But she had on a wig and sunglasses. She filled out an application with false information. She went in and shut the door. And it was a very short period of time, as I recall, that bam, you heard the gunshot. Shot Mr. Cole right in the chest, hit his heart. And then she made her way out of there. And she didn't have any immediate remorse. We had to figure out who did it. We had to pull files. I forget exactly. I'll defer to the record. Y'all may know more about it than me. But what is the punishment when you just decide that another human being is going to die on a certain time, which she did, and you just walk in there and kill somebody? You've made a decision. State of Louisiana made a decision. We can't stop them from doing that. State of Louisiana made a decision. When you do that, the punishment ought to be life without suspension, probation, and parole. Not life without suspension, probation, parole for a certain period of time. Then you get out and get to enjoy your family, enjoy life, and be around Baton Rouge. So I disagree. I don't think she has paid her debt to society. I think there's a big deficit yet to be paid that debt. And she hasn't paid it. They don't think she'd be a threat to anyone. I don't know. Is she blaming the people in this room? Is she blaming me? I prosecuted her. She blamed the lawyer that we pulled the tape, and it didn't look like what I recall. It didn't look like he did a lot wrong in that year that she got blamed. She blamed for. You know, I have experience of family members being got to by the lawyers or other people and showing up. I live in Baton Rouge, inside the city limits of Baton Rouge. So I guess I'm glad here, because at least I know what she looks like if y'all let her out. I would urge you not to do this. She doesn't deserve it. When you make that premeditated decision that you're going to execute another human being, and you do it very cleverly, she could have got away with this with a little bit of luck. If she'd been a little better at that application, if she'd been little better not put it so close to her house, a little whatever. Because the secretary didn't recognize. So I've heard everything here. The only thing I can do is say on behalf of the state of Louisiana, we would request you to please deny this application for compensation. I'd answer any questions anybody has.
Okay, thank you, sir. We appreciate those words and we'll consider those along with these other things. Ms. Tracy Barbara.
Good morning, Tracy Barbera for the East Baton Rouge District Attorney's Office. I apologize for not being present in person, but I decided to bring my congestion and coughs to Healer's office and not before the members of the board. I think this is the first time in my 36-year career I've had to follow John Sinkfield with comments. It's somewhat intimidating, I must admit, and honestly, there's not much more that I can add to what Mr. Core, Mr. Hessick, and Mr. Sinkfield have represented to you. I would just like to bring home the fact that the individual, Carolyn Cobbs, who spoke to you last time, made reference to she went there with questions and she just lost it. And then again today, she said, I went there to ask him questions. My emotions got the better of me. I was not myself. To this day, she is still not being completely forthright with you about her intent when she did just as Mr. Sinkfield described. She armed herself with the firearm, went to the law office, disguised herself. This woman clearly intended to go there and kill Mr. Core, and she still will not acknowledge that. Until she acknowledges that to herself, her family, and to this board, I represent to you that she has not even come close to meeting what this board has historically required before recommending the relief that she requests. She represented to you last time she tried to be a model prisoner. She's being represented to you today as a model prisoner. Again, as I said last time, I hate to be a broken record, but you have had people before you who have served more time than Ms. Cobbs has, who have had 0 write-ups or 1 or 2 early write-ups. 121 write-ups, the last one being an aggravated offense, is not indicative of someone who should be recommended for clemency and released. I stand firm with the Core, Mr. Core, and Mr. Sinkfield and Mr. Hessick, and ask that you please not recommend commutation of sentence. Thank you.
Thank you very much. Appreciate that. And the final speaker in opposition will be Mr. Brant Hardy. Is Mr. Hardy here or on Zoom?
Yes, I am, sir.
Okay.
Thank you very much, Board. I will, in light of everything that's been said, I'd like to address one specific issue. There's so much more that I could say. I've watched the Core family, who I'm very close friends with for almost 40 years, suffer from this. The family, it is a constant source of concern and outcome that today's hearing will bring to bear. In my mind, as you all are aware, there's a tremendous difference as a context of forgiveness and consequences. I'm a mental health counselor licensed here in the state of Louisiana as a licensed professional counselor, practicing over 43 years. I've worked extensively in my practice also with victim-defendant mediation. So I've had the unique front row seat to watch people who have committed very serious crimes ask for relief and forgiveness from families that they've offended. In this circumstance, I can't address all the history that you all have so much more than I do, but the context of what Ms. Barbera and Mr. Sinkfield has said from a public standpoint, there's a practical and common sense understanding here that, life in prison means life in prison. The dynamic of this consequence on this family, wanting their mother to come home, I appreciate that. And I feel for the family, and I encourage forgiveness, but there is a difference between forgiveness and consequence. all of us should forgive when there's an offense such as this, because otherwise we're not released and free emotionally. So forgiveness is absolutely essential. But the consequence, as Mr. Sinkfield said, is a debt that's paid because of the heinous act. And so feelings cannot come into play in this, in my opinion, as a public citizen, but also as a friend of the family. There are real concerns for their safety and welfare. But in this context, please do not commute this sentence that puts anyone at further risk of harm. And I think you protect the family, you protect Mr. Hessick. And I also think the dynamic that was just said by Ms. Barbera, I think the truth is that keeping her in custody is the best outcome for her from a health standpoint, from a mental health standpoint, and also from a real context of consideration for what life in prison without the ability of parole means. So thank you very much.
Okay, thank you, Mr. Hardy. We appreciate those words. I believe, and I could stand corrected, but I believe that's all the speakers that we're going to have, either in opposition or in favor of this request of Ms. Cobb. Now, Ms. Cobb, the next portion, as I think you know, we'll ask our questions, and I'll lead, and then my rest of the panel will have a chance to ask questions, and then we will vote. It's as simple as that. I've got a couple of questions to clear up some of the things that I've heard. Why did you set the appointment to go there to the attorney's office?
Well, sir, I had been trying to see him for a while and I wasn't able to see him, so I decided to try a new name. Maybe I get a chance to see him.
Okay. Where did you get the gun?
I bought it from a pawn shop.
When did you buy it?
After me and my husband separated.
How soon was that before the shooting of your attorney?
It'd been a year, sir.
So you had had the gun a year. Is that correct?
Yes, sir.
Okay. Why did you disguise yourself?
Sir, to my recollection, I didn't disguise myself. I didn't wear a wig.
Your recollection? You know if you wore a wig or not. That day, it's in
no,
your
sir,
mind.
I hate my hair. There was no wig.
Okay. What did you do with the gun afterwards?
I threw it into the water, sir.
Where?
Off a bridge.
What bridge?
I don't remember.
Okay. I've heard some discussions about your mental health. Do you currently take medicine?
Yes, sir.
Were you taking medicine at the time?
I don't remember, sir.
When were you diagnosed with the mental health problems?
Sometimes right after my husband and I separated.
But you don't remember if you were taking medicine. Do you remember what kind of medicine you were prescribed?
Could have been a Valium, sir, or something like that.
Could have been, but what was it? Yes, sir.
No, go ahead. Go ahead.
You don't remember what kind of medicine it was?
I can't say for certain, sir, no.
Okay, that's good. Thank you. Let's see. I'm concerned about your disciplines. Tell me why you have so many disciplines. Is there a common denominator? Is there a something that causes you not to follow the rules or causes you not to get along with people or something? Could you explain your disciplines?
Well, yes, sir. I was, had never been incarcerated or locked up before. And, prison life is different. And you have all types of women from every walk of life. And, I had time adjusting to prison life. And, I think I might have had some bad medication when I was in prison.
Okay. And because reason I say that, and we hear people say they had trouble adjusting, and so they have some disciplines and all, but your disciplines lasted for a long time. Is what concerns me up through basically 2020, but primarily through 2018, you had a lot of disciplines, over 100 disciplines. That's more than just, I would think it's more than just adjusting. Usually adjusting is the first 2 or 3 years. So I was concerned about that. Let's see, I believe that may be all the questions, but I may come back after I hear
I'd like to ask some questions.
Okay.
How long have you been incarcerated?
Almost 44 years, sir.
Okay. I've forgotten things in less time than that, and I can understand 44 years, you don't recall a lot of these things. What do you feel that how long has she been with you?
How long have I been here or how long has she been here?
How long has she been under your supervision?
So she's been here since 1983. I've been here since 2021.
2020. And what kind of prisoner would you say she is?
Like I said earlier, since I've been here and with her, she's been in the assisted living dormitory. So, like I said, she hasn't been any trouble for me since I've been here.
That's what I thought I heard. Are you remorseful?
Sir?
Are you remorseful?
Oh, sir, from the beginning, I was confused and I was in torment.
Are you remorseful now?
I was back then and I still am, sir. I should not have shot and killed Mr. Core. I'm sorry.
Okay.
I let my emotions get the better of me.
Thank you.
Yes, ma'am. Ms. Core, we've heard very important arguments on both sides of this issue. Your life sentence, there's no doubt about it in my mind that it was entirely premeditated. Everything you did from I read, because I was on the board the last time you were up here. And I remember the case from then, and we had a little bit more information leading up to it. And so I know my vote then was not to commute you. Then I've read the letter from the victim's son, which is heartbreaking. And I do understand, because I'm a victim's advocate, I do understand that there are times when, in order for a victim to heal, they do need the same type of closure for a different reason, which is what's been said here. The rest of the family members, they want their nephew or their son to have closure, and he's a very kind person. And he met with your children, from what I understand from what was being said here. And so they had, and I know how victim offender dialogue goes. I know how important that is for a victim and the offender. And it seems like that's what we have that was going on here. So I'm very happy that they had that. But see, right now, I listened to Mr. Prater. He questioned you again. He questioned you, and I listened, and you were still evasive about what you did that day. And I don't even understand the purpose anymore. Where did you throw the gun at? Water. We all live right here in Baton Rouge. And then you don't remember wearing a wig or anything. And how did you get there last time? Seems like the last time I read that you had arranged for transportation to bring you and pick you up. Did you take a taxi or something last time? How did you get to his office?
Ma'am, I have an automobile. I had an automobile.
So you just drove yourself over there, okay. Everything that I remember from reading the last time and this time was that you did go in there with a gun in your purse. That's not the normal thing for people to do. So, you know, I don't buy the part that you were confused and everything. But my heart does go out for the families on both sides. I do want to say that. For the very reasons that they stated. But I did find you continually still evasive today when actually asked about particular crime. So, and about the mental health issue. You were evasive about that too. So that's all I have to say for today.
So how long have you lived in the assisted living dorm? Do you remember?
Maybe about 6 months.
Oh, so you just got moved there? Okay.
Yes, ma'am.
What was the job you had before you moved into that dorm?
It was housekeeping, ma'am.
Okay. All right. I think everybody did a really good job. Go ahead.
How long were you in his office before you shot him?
I don't remember, sir. Seconds, minutes, I don't remember.
Did y'all talk about much?
No, sir.
So you pretty much had your mind made up.
Sir, I just lost it. I was under pressure. So much pressure that I lost my reason, and I just.
What happens when you get out? What happens when you get out and you forget to take your medicine and you get under pressure at Brookshire's?
Beg your pardon, sir.
What happens when somebody breaks in line in front of you at Brookshire's and you've forgotten you hadn't been taking your medicine because everything's fine and you're out of jail? I don't know if y'all have Brookshire's around here. Walmart. Anyway, it's kind of a rhetorical question, meaning I didn't expect much of an answer, but I just wanted to ask that question to tell you that's the kind of decisions this board has to wrestle with, along with everything else that's been submitted. is the safety of the public. So
I have one question for you, Ms. Cobbs, and then we'll be ready to vote. When you went there that day, you went there to kill Mr. Core.
No, ma'am.
Why'd you have the gun?
I carried the gun with me everywhere I went.
Okay. All right. Thank you, ma'am.
I'd like to have executive session, please.
We have a motion. Is there a second? A second. Can you call the roll?
Renassa,
Yes.
Prater,
yes.
Kevin,
Yes.
thank you.
Alrighty, friends, they go to executive session. So this is interesting. It's always interesting to me, these parole hearings, and pardon hearings, and just watching this board work. It's so much of a roller coaster. So we put out the first poll, and by 2-1, you guys felt that the board would side with Ms. Cobb. And then I put out another poll later in the hearing, and 90% of you say they will not side with her. That's one of the reasons why I love watching these things, is things change. All right, we're a little bit... What went on here? The feed got weird. Hold on a minute. Let's try to refresh it. Hold on, we got to reset stuff. All right, we'll come back to the board. The feed got weird. I don't know why. A little glitch there. So while I get that reset, let's do this. Let's go to Judge Boyd. Say good morning.
Application?
No, ma'am.
Hello. Hello. All right, the court is calling 2026 CR 002619, State versus Melissa Ramey. Can I have parties announced?
Lauren Espinoza for the state.
Lauren Lupton, Miss Ramey.
And are you Miss Ramey?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ramey, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the punishment enhancement.
No objections.
Ms. Ramey, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Your charge is possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ramey, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the Bexar County Jail under 1244. There's an $800 fine and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the charge, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor, state offers state's exhibit 1 and all attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. We're proceeding with sentencing.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we just ask the court follow the agreement and give her credit for time served.
All right. Who is Chad Millay to you?
He's one of my friends.
Okay. All right, this is what the court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to 180 days in the Bexar County Jail under 1244, give you credit for any time served. There's an $800 fine. Time and money will run concurrently. There's to be no contact with Chad Millay. It's Millele. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
Yes, ma'am.
All right, because it's a plea bargaining agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you do not make changes, only one or two things gonna end up happening. You're gonna end up at somebody's jail or in somebody's prison, right?
Yes, ma'am.
Because now you're labeled as a habitual. So in certain cases, if you pick up another possession case, you're looking at 2 to 20.
Yes, ma'am.
Or somebody's gonna identify your body, because
Yes,
you
ma'am.
understand?
Yes, ma'am.
So when you are released from custody, you need to immediately go do an AA meeting or an NA meeting.
Yes.
You can go to Lifetime Recovery. There are plenty of places that will help you get back on your feet and help you with any issues you may have.
Yes.
If you continue on this vein, it's not going to go well. You understand?
Yes, ma'am.
All right. Now, here's the other thing. With this 180 days jail, is this supposed to be a judgment satisfied?
It's pretty, she has 84 days.
All right. So this is what I can tell you about that, because people will come to me and they say, I'm in general population. I should be getting 2 for 1. I'm not in charge of your 2 for 1 or 3 for 1. That's something the Bexar County Jail does. I have no jurisdiction over that. What I can tell you for this court, you're going to get credit for the 84 days. You do the math, 180 days minus 84, that's what you'll be sentenced to here. If they decide to give you your 2 for 1, you still have a little bit more time probably left.
Yes, ma'am.
All right.
Yes, ma'am.
Good luck to you.
Thank you.
Thank you.
Thank you, Judge.
Sure.
Judy.
Yes.
Okie dokie, let's go back to the board now to get to that resolution. By the way, I didn't have a chance to say it earlier. Barbara, thank you for gifting the 5 memberships. I appreciate that. All right, back to the board.
I'll make the motion to go back to regular session without objection. We're back in regular session. It's 10:50. And we are prepared to vote. Mr. Crater?
Yes, ma'am. Because I've weighed everything and words are cheap and we've been here long enough. My vote has not changed. I still vote that this request be denied. It's because of the violent nature of the premeditated crime. It's also because of the numbers of disciplines since you've been incarcerated, and it's a lot of disciplines, and they've lasted up through 2020. And that bothers me. because of the severe opposition and well-stated opposition from the law enforcement community. And because of the premeditation. And I still feel like, well, because of premeditation, so my vote has not changed from the last hearing. And my vote is to not recommend to the governor that we do this.
Mr. Tillis.
My vote is to recommend to grant with to 99 years. And I am so happy to see that the family has forgiven this person. And I think 44 years is a long time. I appreciate and feel that you have remorsefulness and hope that some of us will get in our hearts to have mercy and forgive people. So my vote is to grant.
Mrs. Stapleton.
I gotta tell you, I am very torn with this one because I've been on both sides. I'm a victim's advocate. I know about victim offender dialogue and what a powerful method of forgiveness that is, and closure for a victim. And that's what I've heard here today. That means a lot to me. And I'm so happy for his son and his sisters that they've reached that point and have had contact with your children. I do find, though, that this was a premeditated act. Even to this moment, that it was a premeditated act. Like you said, you just spent a minute or so in his office. So there's no way to not believe that you didn't go in there with a gun in your purse to kill the man. And so I didn't know until the brother mentioned that it was a possible death penalty case. They took that off the table. I don't know about that, but a jury decided that it would be life without benefit of probation, parole, or suspension of sentence or anything like that. So, so we have strong law enforcement opposition because it was premeditated and it was such a violent crime. So today I'm going to stay with my, and you've continued to have discipline problems, but now that you're in the assisted living area, it seems like maybe this is a good fit for you. So maybe some more time in the assisted living, your medication may have gotten just right, because that's very important for you to have a life outside of there or anywhere. I don't want to see any discipline problems. So you do have one in latest, I think it was 2020, and it was and all your discipline problems have been aggravated discipline, a lot of them. So yeah, I see June of 2020 that you had one was your latest one. So my vote today is gonna be to deny due to the nature of the premeditation to kill the attorney, the law enforcement opposition, and we still have split victim opposition. And you had excessive disciplinary problems while you've been in.
So, Ms. Cobbs, today you didn't get the vote you needed. It takes four light votes. And so I'm not going to vote, but I will tell you, I'm a little disappointed that you didn't take full ownership of your emotions that day, what happened. I mean, I know you say you lost it, but I think there's more that you need to come to terms with, just like the DA has expressed. So I hope you continue to work on that. I'm glad you're doing well where you're at, but today your application for clemency has been denied. Good luck to you.
Denied. Well, there you have it, my friends. The decision aligned with our second poll, where 9 out of 10 of us believed that she would be denied, and she was. So I'm going to go to Judge Stevens next, but I have him paused because I want to show you his face. He has the best expressions. Holding his breath, glaring at the defense attorney. He's great for thumbnails, I'll tell you, because he just has the best expressions. Anyways, On with Judge Stevens.
To work with her on that. Here's one, I'm gonna set it for a hearing in 4 weeks. So hearing on this, on the motion. Yes, sir. Okay. That her? Yeah, yeah, we're gonna go forward on this motion to revoke probation.
Not today.
But you're not gonna get a bond. You made a big mess here. Big mess. And you're gonna be answerable for it. But we're gonna have a hearing on the probation revocation. That's what's next. That is all. John? On Christopher Chambliss. What are you gonna do, buddy?
That's a competency, Your Honor. I think that we're speaking in.
Let's see.
She didn't have it either. Erica didn't. Checked.
You only see a yellow paper here.
And I thought I mailed those to y'all before I left town.
Oh,
After done.
Took that, and we think confident that there's, is what it is.
Is confident.
He's confident. Okay, then I'll work on that with him.
Not confident of the three that I.
But you still need copies of this.
Yeah, we will, yes, but for now.
There's a motion to revoke probation and I guess a new case, right?
Yes. Okay, so we can get that originally, I think that was all the case.
Today?
Yeah, that's my goal. That had Daniel Jenkins, the same issue. We did some.
Okay, this one over on that stack. Daniel Jenkins?
Same thing. He, that was a complicated, like I said,
Okay,
one of them,
let me see.
see which one he is and which one he says. That's Miss Waters as well.
Is not Daniel Jenkins.
Yeah.
And
then you have Washington, it's just two words on this, so I say that's what we call it.
Shoe.
So I'll get those two.
And then this one. Well, you had the competency docket, yeah.
They all got returned at the same time.
Liz competent.
That's what you had two of his competent, so I'll get those two, Washington and Jay, let's see what I can do on that. So we get those moved to. There's well, it's ready to move, they're not.
Okay.
I think.
Hold on, though, on. The other one, that was, give me that for, yeah.
Thank you.
The not competent, on Daniel Jenkins, I need to make findings on that.
You know, you gotta do it.
You ready?
Yeah, sure.
Does he need to be out here? This is just one case?
He has two.
Is it two?
There's a harassment of public servant and burglary rehabilitation, MTRP. So it's two.
Yeah,
Daniel Jenkins.
Sounds similar.
It's in the files. One underneath the two that you have stacked with. Beth, right on the, no, over there. The two, that looks like three files right there, sitting up by Kim.
I got two files. Is it just two for Daniel, right?
Yes.
Yeah. Does he need to be out here? In cause numbers 21-37149 and 25-CR371. Those are each styled the state of Texas versus Daniel Jenkins. John West, his attorney, is present. And based upon request by the defense, the court ordered an examination for competency. Dr. Edgar Fahn was appointed to examine the defendant in each of these cases, and his examination was accomplished in a report dated March 20th, 2026. The defendant was declared incompetent to proceed at this time to resolutions of his legal issues, as he is diagnosed with a schizoaffective disorder. And that based upon reasonable psychiatric probability, Dr. Rapon states that it would be expected he would regain competency with more intensive treatment. Thus, the defendant is hereby declared incompetent and is ordered to continue treatment for his mental issues with a goal of him gaining competency at a sooner than later time period. All right, so is there anything the parties need to add on this?
No.
Orders, incompetency and treatment will be prepared and, so you will handle that. Good. Daniel, yes. Hold on. Where's Corey? Pretty good. Good job. He was just here. Yeah, he was just right here. When I looked. Then when I started talking about the competency issue, he took off. I don't know if that's.
All right, a little bit chaotic in Judge Stevens' court. Hopefully they get that sorted. In the meantime, let's go back to Huron County, new contestant in front of Judge Prill.
7274 SH. This is the defendant's motion to correct invalid sentences for resentencing. The defendant is present by the Zoom application, represented by attorney Kimberly Bickerstaff, who also appears by the Zoom application. People are represented by prosecuting attorney Timothy J. Rakowski. David J. Wallace, chief assistant prosecuting attorney, appears on this particular file. And Ms. Bickerstaff, you may proceed.
Thank you, Your Honor. I think I'm actually going to make this pretty easy this morning. As an initial matter, the prosecutor has already conceded that OV-19 was scored improperly at 10, which will drop the sentencing guidelines from a standard cell of 14 to 43 to a 12 to 36 in a shaded straddle cell. So I think as a result, that makes some of my claims moot to some degree, because once a resentencing is granted, I will be able to produce and present the mitigation evidence, as well as an argument as to how the child DUI law is to be applied. So I think honestly, the only thing we have for Your Honor to decide this morning would be the issue of OV-17 and whether it should be scored. This concerns the degree of negligence exhibited when operating a vehicle. And in order to score it, wantonness is required, which is a greater degree of culpability than just recklessness. This standard is not merely an elevated form or enhanced form of negligence. I mean, there's case law, I guess there's a lack of case law. There are no published cases where OV-17 was scored for an OWI at all. There are several unpublished cases, but none where there was no accident or injuries involved either. I mean, all we have is a witness who, not meaning to take anything away from this boy, but he's an autistic young boy, didn't have a driver's license, and indicated to his mother that he was afraid. But the credible witnesses, the police officer actually pulled over Mr. Thomas, did not witness any driving dangerously, speeding, swerving, or being all over the road. There was no accident, and we would argue as a result that OV-17 should not be scored. This would really open up OV-17 for being scored anytime someone is convicted of an OUI, and that's not what we have here, and that's not the intention of OV-17. Thank you, Judge.
You're welcome. Mr. Wallace.
Yes, Your Honor. As counsel stated, we do agree that OV-19 needs to be listed properly scored, so we're not objecting to that part. But in terms of OV-17, and the court I know has read the brief that supplied, we would contend, Your Honor, that it's properly scored. That the argument here just mentioned that, well, anytime anyone starts to order DUI, that would be sufficient. No, that's not sufficient, Your Honor. It depends on what's going on here in the case. In this case, we have a witness who stated, or not stated, who then provided information to his mother He's scared because the defendant is all over the road. I'm scared because of that. Now, counsel said, well, because the officer didn't see anything, didn't happen. Essentially, she didn't say those words, but essentially, no, Your Honor. Just because the officer comes in a little bit later, we could have possibly the event, okay, if I see someone, I need to be even more careful now. But at the time, based on the child's reaction, based on the child's actions following, he then took steps to say, Mom, I'm scared. Something's going on here. He's driving on the road. We need help. Call the police. And that's what happened here. To require counsel in her brief argues essentially that, well, there's no injury, there's no death, there's no injury. But therefore, you can't apply it almost, what they seem to be arguing. And that would make the OV 17 also, on the other side, essentially useless. Requires, because of that, you have charges that regards that as well. And I would also, as I noted in the brief, reckless driving, which could be a downside to what we're talking about here, does not require any type of injury. It's not the harm that happens, it's what's going on that could be in harm. We submit that based on the fact that the court had before it, it was properly scored, and we asked the court to so find.
Hopeless child 6 or 7.
I'm sorry, what?
The age of the child was 6. I think this child 6 or 7. I think the
No,
child was a little
I think about 14.
Oh, 14.
Yes. And there was another child in the car who was the mother, who was the child of the mother who asked Corey to drive that day, who, that child and that adult were not afraid, did not indicate there was driving dangerously, nor did the police officer.
The court have any other questions?
I have no other questions. Thank you. Rebuttal argument, Ms. Bickerson.
My only argument I would make, Your Honor, is it wouldn't make OV 17 useless. There are several unpublished cases where there's excessive speeding, where there's accidents, where there's severe injuries happening. They're swerving all over the road. There are things that make it more than just recklessness. And this is not a situation of more than recklessness. So we would ask that it not be scored.
Very well. Well, one argument could also be made relative to OV 19 as well, and that it was waived. There was nothing in the file to indicate an objection to OV 19. So one could state that that argument was waived as well as OV 17 based upon lack of objection to it. However, this court finds relative to OV 19, I agree with counsel, because at the end of the day, and this is the truth in any drinking and driving type of situation, you shall submit the request of peace officer to breath test, blood test, urine test, but you have the right to say no. You have the right to deny a person a preliminary breath test, a PBT. PBT, if I recall still correctly, it's been a few years, only about 11, but I believe it was merely a fine and there were no points. I thought it was a $100 fine, at least back in my time, relative to practicing. So it appears that the defendant's behavior that warranted the scoring of OV-19 was really exercising the exercise of his rights not to submit to the chemical and or preliminary breath test. I believe it's the PBT is what the issue is here. And so I agree. OV-19 was improperly scored, which will require a new sentencing. But now the issue pertains to OV-17. And under OV-17, the court is to apply a preponderance of the evidence standard relative to that guideline. In OV-17, you can score 10 points under degree of negligence exhibited if the offender showed a wanton or reckless disregard for the life or property of another person, citing MCL 777.47, parens 1, parens A. Or 5 points, the offender failed to show the degree of care that a person of ordinary prudence in a similar situation would have shown. citing MCL 77.47 parens 1 parens B, or the defendant was not negligent. Now, the defendant had pled to operating while intoxicated with a minor in the motor vehicle, and this would have been a third offense. And regarding the brief, regarding the argument relative to having some of the facts the second time, I agree with that as well. So I'm placing that on the record. But when you look at OV 17, here in this case, and that's why the court inquired, this child, apparently 14 years of age, has a mental health condition, calls his mother, and reports, according to the pre-sentence report, driving all over the road. And dangerously. That's what it says, and that the child expressed that he was scared. That's all the court has to go on. And so, again, operating while intoxicated, just generally speaking, if there's no accident or injury or anything like that, you wouldn't be scoring OV 17. It would be not considered, 0 points, move on. Here, there was no injury, physical injury, or death. There was no accident involved. The court takes judicial notice that according to the pre-sentence report, the defendant was operating with a blood alcohol content of 0.224 and had 2 minor children in the vehicle, one of which was 14, the other, what appears to be much younger. And no reports from the other child, but a report from the 14-year-old. And so the question is that either wanton or reckless disregard for the life or property of another person? Not necessarily the property, but certainly the life of the individual. And I stand by the preponderance of the evidence standard. If you have 2 minor children in the vehicle, one of which reports being scared, and that based upon a phone call from that child to the mother somehow dispatch gets called, the officer did not see any bad driving, and there's nothing in the record to indicate that he was driving other than, or had bad driving to the police officer. But the young child reports what happened at the time. Now, there's an argument too that the child has some sort of mental health condition or autistic. I understand that. But if the child were that severely limited, why would they call to begin with? And there's a lack of case law regarding this, but I guess it's just common sense from the court's perspective, which I appreciate the arguments of counsel here, but when you decide to operate a motor vehicle with a 0.224 bodily alcohol content, have 2 minor children in the vehicle, to me, it only makes common sense under preponderance of the evidence standard that the offender showed a wanton or reckless disregard for the life or property of another person. Also consider the fact that the defendant previously was incarcerated for drinking and driving related matters. So he had a more sensitive understanding relative to why you would not have anyone else in the motor vehicle. Respectfully, OV 17, the court finds it's properly scored. However, we will we'll schedule this for resentencing under the OV 19 correction, which would be a 12 to 36 guideline range, and that sentencing date will be for, when would you like? Yes.
Very quick.
2 weeks, a month? 2 weeks? Any problem with 2 weeks for sentencing, Ms. Bickerstead?
Could we do 3 instead? I already have 3 in-person hearings that week, and I travel all over the state. So if we could do the week of the 27th, that would be better for me. And will my client be there in person?
You wish to have him present?
I guess I need to speak to him about that, but which I would like to do after this, after we're done here. Just if you could put us in a breakout room, that would be great.
We'll certainly try to accommodate.
Okay.
April 27th. April 27th at, available at 9 a.m.
Where are you guys located?
That extra county tip of the thumb.
Okay, so I'm in Oakland County. 2 hours, is that about it? Or I don't really know, to be honest. I've not been to your court yet.
Give or
Sorry.
take.
Give or take.
Yeah,
How about, can we do 10 o'clock that morning?
Let's make it 11.
Perfect. Thank you.
Mr. Wallace, anything to add to people?
And just as a note, Your Honor, what the defendant now had been, even though this is a resentence, having the sentence now in the corrections, defense counsel would need to do the writ if they want to have him here presently.
Correct.
Okay.
Yeah, Mr. Steph, you'd have to prepare the writ, and you also have to prepare the order relative to the court's findings today.
Okay, and would I put the resentencing date in that order, or do you want a separate
can.
note? Okay, perfect.
Put it all in one.
Okay, and if you wouldn't mind just moving us to a breakout room, I would appreciate it.
All right, we'll try to accommodate this. Thank you.
Thank you, Judge.
You're welcome.
Alrighty, friends, let's head back to Judge Stevens.
What was? What was his nickname?
Golden Joe. You were going to tell me something, weren't you? Do you know what room he had at the Roosevelt Hotel when he lived in New York?
The best.
The best one. I would be saying he's a good dude all day.
Yeah.
How do we do that?
Well, that baseball. He's talking about baseball. Michael Jenkins, man. That's Hey. I'm on 2 or 3 cases. Most of it's confusing. What time did you? Ryan, how much did you say? How much time?
4 weeks, please, Judge.
4 weeks. And you are Java. 44 CR 99 is called, and you are here with your attorney, Ms. Manalden, and the state's attorney. There is a motion to revoke unadjudicated probation that has been filed as of November 7th, 2025. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Judge.
And the state's here with the probation office and defense and defendant's attorney. The defendant and his attorney. Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand.
And Judge, can I put a few things?
There was a valuation
There was.
made at the request of the defense for an issue suggesting evaluation to determine defendant's competency. Dr. Ed Grippon, licensed of titles, was appointed to evaluate the defendant for competency. In a report dated March 20th, 2026, the defendant was deemed to be competent to proceed to a resolution of his legal issues based upon Dr. Grippon's report. This is a 4-page report. We're calling it Court's Exhibit 1 this date. On this docket, any objection by the parties? No objection.
None.
It's made a part of the record for all purposes. Oh. In summary, sir, this motion to revoke unadjudicated probation filed on November 7th of 2025 states that on December 9th of 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a 3rd-degree felony. Is that true, sir? Allegation. There are 11 allegations. What does the defendant intend to plead to, and what pleading through to anything?
I'll take responsibility, on what I did, but As far as me being drunk, sir, I was not.
No, there's, okay, number one states committed the offense of assault by threat on or about October 24th, 2025 in Jefferson County, Texas. Number two states you committed the offense of public intoxication. Number three states you committed the offense of criminal trespass.
Yes.
That's,
I'll tell you why. I'll tell you why.
well, no, that's okay. Is that what you want to plead to?
Well,
Is that what you're intending to plead? True to?
Yes, I mean, I fell asleep on the bench outside the restaurant. That's it.
Judge, can I put some things on the records, please?
Yes.
Okay. My client's already been sworn in, but I just want to make sure you understand what we're here for today and all your potential options. So you understand that you were put on deferred adjudication, probation, deferred or unadjudicated probation for evading arrest with a vehicle, right? And that's a third degree felony.
Yes.
So the range of punishment for third degree felony is anywhere from 2 all the way up to 10 with a fine not to exceed $10,000.
Yes.
So whenever you were put on that deferred probation, they let you know that finding of guilt was deferred for the period of probation. And if you completed it, it would be dismissed with stayed on your record. Is that right?
Yeah.
But if there was a violation, you could come back and revoke that probation and then give you a conviction for the offense. So now that we are here at this stage for a motion to revoke probation, you kind of have 3 options on how to proceed. And we've talked about what those options look like. Is that right? Sorry, she just has to take down everything that you say. So one of those is going through with a contested hearing where the prosecutor would have to prove the violations against you by a preponderance of the evidence. And then if they do that, judge could revoke your probation and sentence you anywhere within the range of punishment for a third degree felony. Is that right?
Yes.
You understand that option? You understand another option is to voluntarily plead true and go agreed to a resolution with the prosecutor, which he's offering a resolution of 4 years. Is that right? We've talked about how he's offering the resolution of 4 years.
Did you know that?
Yeah.
Did you have enough time to think about it though and consider it?
Well, I mean, I believe on 4 years, he wants to do 4 years time for this, sir, but.
No, nobody wants to do a day, you know, but I mean, that was.
I understand. I understand.
When did you find out about the offer from the state?
I found that excruciating.
No, when did you find out about it?
The first time I came to court.
Okay, so you've been considering, you've had time to consider it. Okay, that's, I just don't want to rush it. You have a fair, reasonable amount of time to consider offers.
So we knew about that 4-year offer and we've talked about that, right? And you understand that would look like voluntarily pleading true to the judge, but going agreed to the punishment. Correct?
Correct.
And then the third option would be to go involuntarily plead true to the judge, but to go without a resolution where a judge would be deciding what the potential punishment would be after that. Sorry, you have to speak out.
Yes.
And you understand that if you voluntarily plead true, that would be enough to revoke your probation.
Yes.
And then if judge does revoke your probation, then he could sentence you anywhere within the range of punishment for a third degree felony because you were on deferred. And you are choosing to go to judge and voluntarily plead true. Is that the?
You need a few minutes to talk about it and think about it.
I mean, I want to get this,
Well, I don't rush it. There's some things here. Do you need a few minutes to talk to her about the options so that you know them? So you don't talk about them in front of everybody?
I mean, I don't mind talking in front of everybody.
Judge, I feel like we have talked about all.
We talked about it, Judge.
Oh, okay. All right. And you had enough time to think about it? What direction you want to head?
But they've only came at me with one offer from day one.
Well, I mean, that's the way it may be.
That's the only offer you're gonna get.
That's their domain. That you have to consider it. You have a reasonable amount of time to consider it, and those are your options. You can either accept the deal or not, depending upon what you plead to. Then I am the decision maker in a motion to revoke probation. You don't get a jury.
Well, Judge Stevens, I just want to say, while I was going through psychosis.
Hold on.
From the risks.
Hold on. But the first step is what option? Then you can have a chance to explain and she can.
I just want to go and handle it today. So,
sir,
I just want to handle this today.
Okay. In what way? Do you want to, are you willing to accept that deal?
No, I don't
or reject that? Then you're going to have to come to me.
Not come to you.
That looks like either having a contested hearing or pleading true voluntarily to the judge.
I'll plead true voluntarily to the judge.
Okay.
And then each side gets to sound in to add any additional information that I will consider, and then I will make the decision, and then that's it. You're gonna have to live by it. You're looking at a third-degree felony, no less than 2, no more than 10 years confinement in prison. Or I could revoke your probation, sentence you up to 10 years in prison and place you on regular probation. Or I could continue you on deferred or unadjudicated probation. Those are pretty much the options. All right. Anything else on that?
Thank you.
All right, well, here's what I'm gonna do. And I need to take a couple of minutes just for a meeting real quickly, okay? Hold on.
Okay, judge is going to do his meeting. So we'll get back to court in a second, but you know, as I'm putting together this show, I get a lot of things fed at me, and not all of it is court related. Some of it's like news and whatnot. But there's an interesting post on X from NASA. And this was put up at 8:01 a.m. this morning. And it's an image of the moon. In case you're not aware of it, the Artemis 2 is currently approaching the moon, ready to do a flyby of it, so go around it. Which, you know, was supposedly what happened during the Apollo missions, right? But so they show this picture of the moon, and the picture is kind of off to the side a little bit. So to the right side of the moon is the part that we always see in the sky, but then there's a little bit of the dark side, as they call it, the back that doesn't face the Earth. But it says, a new picture captures the moon's near side on its right side and its far side on the left. The Artemis 2 crew are the first to see the far side with human eyes. So, are they saying Apollo never happened? Because those missions specifically went around the moon. They orbited. So, that's really weird to me. I don't know if it's just a mistake or if it's an admission. I'm not trying to be conspiratorial here, but super, super weird post on X from NASA. Anyways, it just caught my attention. Let's go back to Judge.
In summary, I've already sworn you in. In summary, this again states that on December 9th, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of evading arrest or detention with a motor vehicle. Is all of that true and correct?
Yes.
Number one states you committed the offense of assault by theft on or about October 24th, 2025 in Jefferson County, Texas. True or untrue?
Untrue.
2, you committed the offense of public intoxication on or about October 24th, 2025 in Jefferson County, Texas. True or untrue?
Untrue.
3, you committed the offense of criminal trespass on or about October 18th, 2025 in Jefferson County, Texas. True or untrue?
True. Can I state why?
Yeah, you will, but we're going to go through the other. We're going to go through this first and then go back to it. 4, you committed the offense of public intoxication on or about October 9th,
Not true.
2025 in Jefferson County, Texas. Untrue. 5, you committed the offense of disorderly conduct with abusive, profane, or vulgar language on or about October 7th, 2025.
Also, true.
In violation of your probation order. That's disorderly conduct. That's a Class C misdemeanor. 6, you failed to immediately report to the probation office you were released from jail on October 7th, October 12th, October 21st, October 27th, 2025, in violation of condition 9 of your probation order, which states immediately report to your probation office any change of address, employment, marital status, or any arrest, and provide documentation of the source and amount of all income for the household, including yearly tax returns. Anyway.
Untrue.
Okay. 7, you failed to provide verification of performing community service hours as required. True or untrue?
Untrue.
9, 8, you were at a location other than your residence at 3:15 a.m. on or about October 7th, 2025 in violation of your curfew requirements of your probation order. True or untrue?
Untrue.
9, failed to abstain from the use of intoxicating substances. You were arrested for public intoxication on or about October 9th, October 24th, 2025. True or untrue?
Untrue.
10, you failed to enter and successfully complete the defensive driving class in
True.
violation of condition 26 of your probation order. True or untrue?
True.
And 11, you failed to pay court assessed fees as of October 27th. You were in arrears $629 in violation of your probation order, which is to pay all fees timely. True or untrue?
That's true.
That's why?
That's true.
Were you able to pay?
No, sir, at the time I was not.
All right. Here's what I'm gonna do. I'm gonna take some other matters out. If we're gonna have a hearing on this, which is what I want. I want to hear all about this guy since he didn't do anything essentially that the motion states.
We can't do that today. If I got to prove up all these public intoxications, I got to get police officers here.
I'm gonna have a hearing on it.
Yes, sir.
Okay, on the whole thing.
If you'll set it for here.
Okay, when can we do that?
Just a couple of weeks.
48 hours?
Yes, sir. No, well,
Sir, the public.
I'm sorry, sir, I'm speaking. We're talking. You've had your chance. I know where you're coming from. You've got a right to plead untrue, but there's so much I want to know as much I can about you with these allegations. There's too many to ignore. We're going to find out and get to the bottom of it. And I want to hear all the evidence and just see what is true and what's untrue out of those 11 or 12.
plus I have to find out what Mr. Kimmler's schedule is also, Judge, because he's the one that had a threat made to him at his office.
I didn't threat by Kimmler.
You know what?
That's
one more outburst and you're in timeout, just like we put the third graders in school when I was a teacher. Don't do that. Follow the rules, please. You know why you're here? You didn't follow the rules.
Yes.
You've already pleaded true to several rule violations. You're not a rule follower like we all are supposed to be.
Yes, sir. So if we just reset a couple of weeks, make sure I got everybody lined up.
Judge, I'm gonna be here for another MTRP matter on April 16th. It's next Thursday. No,
We don't have anything on the 16th. It's gonna be the 14th. You're gonna be gone.
I'll be at seminar that week.
The judge's house.
Thanks for keeping that a secret.
Region 8 conference. Yes.
First opportunity. Sooner than that, please. Can you get sooner than that?
My staff.
Mike said it's.
Thank you. I appreciate you. Sure. I appreciate you.
We can do it, we can squeeze it in during a trial day. Yeah, put it on that week,
Okay.
which is
April 27th.
April 27th. It's 3 weeks. You know, that's all, that's recent.
All right. We have a commitment here tonight on to 11% more, Judge Boyd, and I'm a little behind today on that commitment, so let's go there.
All right.
I won't know until the Supreme Court rules whether or not I'm a citizen.
All right. So, defense, did you all submit an external hard drive? I know there's some, okay.
Okay, so they're in the process of trying to get all the pertinent discovery.
All right, so I'm gonna recall this in June. And by that time, you guys think you'll know if you have all the discovery?
We should know about
I
that.
believe so, Judge.
All right, so what date in June?
30th.
He's like June 30th.
Oh,
June 30th?
Norma, Well, you know what? If you don't ask, you won't receive.
Right.
You know, I remember one time, the very first case I had, Bert Richardson was the prosecutor, and I'm a brand new attorney. And that was back in the day where you had the standardized bail sheets. So you knew
Right.
what the ranges were. And so we're in the office and it's Bert Richardson. You remember Grantley William Arthur Box Hill?
Right.
He was my investigator. And it was in the 226. So we're sitting in the judge's chambers and Bert is there. He's like, Judge, she wants a bond reduction. And you know, when you're out of law school, they say file a motion for everything. But back in the day, you didn't file motions. Even though I had my motion, I'm ready to do my argument. I'm like, what are we doing in the judge's chambers? This should be on the record. That's what I'm thinking mentally. So I go back there and they're like, well, now my guy is charged with possession with the intent to deliver over 400 grams. So they're like, well, Stephanie, what do you want this bond set at? And I said, well, $20 sounds good to me. I'm like, I have that in my pocket right now. And so everybody's like, ha ha. And in my mind, I'm thinking, I'm dead serious. But afterwards I come back, ha ha. And so Bert Rich is like, I think 1,500 would be enough. So
That's not bad.
we set it for 1,500.
It's good.
In that case, it ended up getting dismissed on my motion to suppress.
Good.
But those are the days. It's hard to believe we're coming up on anniversaries.
Yeah, and those were good old days.
Yeah. I need to do a barbecue plate sale or something because a group of us from law school for our anniversary, you know what we decided to do?
Wow.
We're headed to Paris to see
Nice.
Celine Dion.
Oh, wow.
Our hearts will go on. So we'll see. So we're trying to see about the tickets. So they go on sale on the 10th.
So you'll be Europe, but you're not on a ship.
Oh, no, I don't do that.
Could you see that Titanic?
Oh, my
Make sure.
goodness.
All right.
Okay, let me just tell you, one, I'm not going to do a cruise, even though people should say you should do once in a lifetime.
Yeah, same.
I can't swim. And I would hate for something to happen. And then my mom would be on every news channel. Somebody kidnapped my baby. And then you see a video of me, hey, just going off on the cruise. So that will not be happening. No. Even when I went to Greece and was hitting all the islands, I didn't go by cruise. Yeah. So we flew. Now, mind you, you take a boat to go to your next island, but it was flying, driving.
Oh.
It was awesome. We ended up stopping by the restaurant called the Jackie O, because they said Jackie O used to go there.
Oh.
I went there. It was okay. All right, Norm, I need a date in late June.
Oh.
Look at that.
See, when you go ask for it.
Are you gonna pay? And see, Alfonso Alfonso's like, well, we can do it at the beginning of June.
No, I didn't hear if it was June 3rd or 30th.
Yeah.
I heard three.
Yeah.
All right, so they're gonna be back on June 30th. And what they have to make sure is that they have all the discovery so they can represent you. So I know sometimes being in jail, it's a while, but they need their discovery. And then I see that you were in the hospital at one point. All right. So is there anything else?
Nothing at this
Well,
point.
Judge, sorry, just one thing. He did pick up a case in the jail on April 2nd. No one's been appointed to that, so if we could just have these
All
five
right.
attorneys placed on that.
All right, Norma, if you can, he's alleged to have committed an offense while at the jail. So if you could add the 2 attorneys for that. All right, is there anything else?
Nothing.
All right, thank you. Thank you. All right, thank you.
So we don't really have, excuse me, we don't really have time to dig into much more. So we're going to close it out here in a minute. But before we do, so I Googled Apollo 8 description of far side of moon. In December 1968, the Apollo 8 crew became the first humans to see the lunar far side, describing it as rugged, gray, and heavily cratered, markedly different from the smoother near side. William Anders described it as looking like a sand pile or plaster of Paris covered in countless holes and bumps. Yet NASA tweets or X's or whatever out a little while ago about how Artemis will be the first crew to see the far side of the moon with human eyes. The world is weird. I don't know if it's just the people running NASA now don't know history, or if they're trying to tell us something or what, but it's a weird, weird world. Anywho, I hope y'all had fun today. I did, so much so that we'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier for your channel member. And oh, by the way, In the Blind with Mike and Dan tonight, 7 p.m. Eastern, 4 p.m. Pacific. So do join us for that, because Barbara just dropped a link in the chat. That's a fun show. Check it out. And then also, if you have not already, join me over on Substack, dansoul.substack.com. You can find me over there, so do that, because I've got notes from a couple of things I saw today that I might write about. Anywho, go have yourselves a good day, and we'll see you all soon. Take care. God bless.